permitted to file an application as at 4:39, and in the course of the day, I will file the certified copy.
What you see?
Without certified copy, I am taking a leave to file an application as at 4:39.
Why?
But the copy is not ready at the end of the day. I will maybe get the copy. So if you
Get the copy, then fine. What is the problem?
actually, my lord, this is a statutory bill that was rejected by the TGM Jalpaiguri. For that reason, I am seeking.
So we have to grant bail just now.
No, my lord, I am seeking to file the application
দিনে করে দেবো।
by tomorrow.
Get it by evening and file it, then it will appear in the list. Yes. ও যদি নাম্বারটা দিয়ে দেয় তাহলে yes. What don't give it to us. Obtain the certificate copy, file, give the number to my court officer. Yes.
My lord.
13th of February, your lordship has done the petitioner on bail on 10,000, surely 10,001 local.
হ্যাঁ।
So the petitioner is unable to furnish the local.
সে বললে হবে, সবাইকেই তাই বললাম।
If it is mentioned that fixed deposit, then he will.
No. Arrange it.
Otherwise, he will not be released.
He will be released.
A very poor person also is not able to furnish the local. Kindly consider.
Come with
Instead of local surety with.
that is your choice, then come with an application.
Mention exactly. File the application.
File the
My lord, seeking leave to mention this matter for upgradation lordship.
which one?
My lord, item number 99 in today's list, it is my lord under the heading order 41 rule 11. Your lordship heard the matter on the very first day of the circuit. My lord, although there was a direction for some notice.
What can we do? We are trying our best.
Lordship, kindly keep it, kindly update lordship, because my lord 20th, the last date given, day after tomorrow is the last date given, otherwise my lord the position will be taken. It's a eviction suit, lordship. Lordship, kindly update lordship.
Let us see, ওটা কি ওই একটা order 41 mentioned বলে দিয়েছিলাম, ওই heading এ কালকে দিয়ে দিই। Let us try your luck. It will be upgraded. Let us see. Yes, any other mentioning?
Your subject to your lordship, can sanction my lord, may I make a prayer before your lordship, my lord?
Yes.
My lord, item number 69, we may not reach, my lord. Your lordship, kindly my lord, take up this matter anytime suits your lordship today, your lordship. This was filed last my lord, Monday, but it has not been reached as yet, your lordship.
What was the matter about?
Matter, my lord, very short point is involved, my lord. The petitioner was a contestant, my lord, in a recruitment proceeding in the recruitment process, my lord, for the post of assistant professor in English, reserved for SC PWD. That was the reserved seat. He also participated in this election process and he was impaneled, but has not been given any appointment for the region, my lord. There is a post according to my submission is concerned, my lord, there under rule 4 of the rule, my lord, I am protected, but that has not been done.
Which is the matter?
Other section,
Which is the matter, madam? Item number?
item 69, my lord. It will not take more time, my lord. Your lordship, kindly have a
Who
look.
is your other side?
My lord, other side, my lord, all of them have been my lord, already
Then
notified, my
how
lord.
will we know that? Who
Yes,
is
yes,
the-
I shall. My lord, the advocate on record, my lord, before your lordship, my lord, he will inform all.
Let us see how can we.
Milord,
বলো বিকেলের মিনিট।
Milord, under extreme compulsion, Milord, item 58 of your lordship's list, Milord, if Milord kindly, Milord, have served notice on the other side. Milord, if it can be taken up tomorrow, anytime subject to your lordship's convenience. Milord, the only urgency is, Milord, I'm
Why
sorry.
the date, when the date has been fixed?
Milord, your lordship fixed it today.
Yes, Mr. Poddar said.
Yes,
it
Mr.
was
Poddar
on-
said, Milord.
The date has been given now.
Milord,
What is the problem,
Milord,
sir?
Milord, the execution, Milord, the
আরে এক্সিকিউশন তো তার আগের ডেটে হবে না।
no, Milord, the cost has been deposited. Your lordship, Milord, upon mentioning by Mr. Poddar, your lordship said your lordship will take it up today.
No, we have upgraded it, Mr.
Yes, Milord.
We have, it is already, let us see how far we can reach.
Grateful, Milord. If it doesn't reach, Milord, I will take another chance at 2 p.m. Kindly, Milord, allow.
Yes, call the list.
Your lordship, kindly will take up at 3 p.m., 4 p.m., anytime your suits your lordship, my lord.
It cannot be done today, Miss.
My lord.
Ismail, it cannot be, it will be upgraded. Let us see whether we can take it by tomorrow or not. We will try.
As your lordship, grateful to your lordship. As your lordship.
Yes, call the list.
For the petition.
I am for the state, your lordship.
अपनी एक्सपर्ट আইডি আপনি তাহলে যদি গ্রাউন্ডটা যদি মনে হয় অ্যাডমিট করবো ফর্মুলেট করে নেবেন নোটটাও গ্রাউন্ডের এই শুনো
Well, on the grounds of protracted period of detention, I am paying for bail for lordship, because I have been custody since 8th September 2023. And yeah, charge sheet has been filed on 29th February 2024. And
8 September 2023
three, and charge sheet has been filed, my lord, on 29th February 2024.
Hmm.
As on date, the copy has not been supplied, my lord, because the warrant of arrest against the owner of the vehicle is still pending. That is, I have been custody continuously for 529 days, my lord.
recovered from you
Recovered from my
Another
vehicle,
396.26 kg of gaja, exclusive possession from this petitioner.
from the vehicle. And
which
in
you
this-
were driving.
my lord,
Yes.
In this regard, my lord, I am permitted to mention one judgment of the Honorable Supreme Court, where the punishment, where the detention was 1 month, 1 year, 6 months. And he, Honorable Court of Justice,
Justice Dotto.
no, my lord, this is passed by Honorable Justice, Surya Kant and Abhay Biroka.
আরে আমাকে দাও কপি একটু দেখি
সবই জানা।
কই
Nawaz Khan is against you, sir. Nawaz Khan has been dealt with. সবই জানে এখানে বলতে।
I am.
You are the expert, you know everything.
দেখি 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 কপিটা
Earlier dismissed for default. Earlier dismissed for default.
Subsequently, it has been restored. Due to my mother's illness, I was absent. The case was dismissed for the court.
No.
I think this was in a subsequent judgment, it was said that it shall not be treated as a precedent. I may be wrong.
I am not sure. Maybe I have not seen.
How much recovered
396.26 kg, my lord, of ganja.
from him?
Yes, my lord, exclusive possession from this petitioner.
There is no possibility of immediate commencement of trial.
What is the stage charge?
My lord,
No.
on the charge sheet submitted, we are waiting for the execution of the warrant, my lord,
Against
we'll-
whom?
against the owner of the vehicle. We'll speed up the case, my lord, after getting the execution report.
When the charge sheet filed?
Charge sheet filed on, my lord, 29th of February 2024.
1 year ago. 1 year ago, charge sheet has been filed. Both in any statement condition, my lord, I will cover the investigation.
A huge quantity of ganja, 396, 20 kg is the commercial quantity, my lord.
How do you distinguish this order?
I will see this order.
I've seen.
That order goes. The welfare was directed by the honorable Federal High Court and appeal was filed by the Supreme Court. And the Supreme Court has enlarged on the petition on case.
2022, no?
2022. You are in custody since?
Since 8th September 2023.
1 year,
5 months and 10 days, my lord. Toxic filed, my lord, 1 year ago.
Records reveal that the bail application was earlier dismissed by court, dismissed for default on 3rd January 25. However, the said order was subsequently recalled by an order dated 11th February 2020. So Mr. Bhumik Learned Advocate appearing for the petitioner submits that the petitioner is languishing in custody since 8 September 2023. And though charge sheet has been filed way back on 29 February 2024, there had been no progress thereafter. In the said conspectus, the petitioner may be enlarged on bail on any stringent condition. In support of such argument, reliance has been placed upon a judgment delivered in the case of Nitish Adhikari, alias Bappan, তিনজন জজ
On kingdom.
আছে
Judgment দাও তো একটা তো।
নওয়াজ খানের রেফার
না, দিলে তো আমি বলবো।
in the case of unreported order passed by the Honorable
Item number two.
Yes,
My lord, I am on behalf of the it's under section 21C.
21C.
21C, my lord. The petitioner was arrested on 24th February. 350 days,
24th February 24
24th February.
of this year,
No,
last year,
last year.
24, yes.
Today is 355 days. My lord, the charge was submitted at 3rd July 24.
Hmm.
My lord, the previous rejection on December, after filing of charge sheet, everything has been discussed there.
My lord,
Same grounds have been repeatedly brought before
my
the
lord,
court.
the astronaut chemical was sample was received 1st March 2024. And the report was sent 24 June 2024.
What do you say about the rejection, sir?
My lord, rejection only the ground, the
Same submission was made. on-
Same.
Same submission.
my lord, there is a violation of rule 14, rule 14, rule 12, and rule 13, my lord.
So, none of these are directory, mandatory email or a directory email.
My lord, in also the violation of 352 subclause 3, my lord. The delay is 3 months. 3 months
352,
of inventory and certification.
352 of
352 of NDPS, sir.
C52.
My lord, 250.
he will
My
say.
lord, 52 A subclause 3, my lord.
After আমি একটা
My lord,
Hmm.
my lord, violation of rule 12, rule 13, and rule 14 also. The petitioner is custody more than 355 days.
My lord, commercial quantity, huge quantity of
My lord, I relied
from the conscious
judgment.
possession of this petitioner, my lord, total about 7.247 kgs of tablets, my lord, huge quantity.
My lord, I
The-
relied to judgment, my lord.
Sir, what had been the change in circumstances after 3rd December? Answer us.
My
3rd
lord,
December, this was argued by you. Are we sitting in review of that order, sir?
my
Can
lord,
we do
kindly-
so?
Kindly consider the
We have-
rules.
Rule 52A is a procedural irregularity. Supreme Court has said that cannot be a ground for.
Delay.
Delay was there when you moved.
My lord, 3 month delay, my lord.
আবার বলে চিরঞ্জিত।
এটা কি?
We have to proceed on the basis of the findings of the court. The learned advocate.
My lord, same ground,
No, my lord, in the,
my lord, same ground, left bail, my lord, kindly see.
that was a different case,
No, my
different
lord.
case, my lord, it's different. Moreover, কত delay আছে? এখানে 3 months.
3 month, my lord.
My lord, we have here also, my lord, Justice Subhashachi Bhattacharjee, he has rejected an application where there was 5 months delay.
No, my lord.
That was also considered. So it varies from cases to cases. Why is the delay?
But there is delay.
আসুন, the learned advocate appearing for the petitioner submits the
In this case, my lord, our George's lordship candidates about the case number 12. Particularly, my lord, the case number 16. That charge sheet has been filed without FSL report. In this regard, my lord, under George's lordship candidates about the observation part of the two honorable benches.
Charge sheet was filed on 12th December 24.
My lord,
My lord, without FSL report.
We are on February.
thereafter supplementary charge sheet was filed within time, my lord,
My lord,
FSL.
with the FSL.
my lord, so far the case is concerned. And at the end of the 180 days, we have filed an application for first category rebate. That was turned down as the charge sheet has been filed without FSL report. And in that point, my lord, I will draw your candidates about observation.
When was it last rejected?
This is the first time. In that case, my lord, can you see the page number 2, paragraph number 3?
With the larger bench decision of Supreme Court has come, Hani Pansari, if the larger bench decision,
Have you? Yeah.
keep it,
Larger bench.
Hani Pansari versus state. It are referred to the larger bench.
In this case, charge sheet has been filed.
Yes, Mr. Chakraborty.
My lord, it's the fact that charge sheet was initially filed, Your Honor, but actually.
Within
the-
180 days.
Yes, yes, and the statutory period, it can be extended up to 365 days.
No.
Even if, my lord, the investigation time is first is 180
Where
days.
is that 365 days you have said?
But
It's in the act, my lord.
The NDPS,
364A subsection 4.
NDPS
That
Act.
has been also been curtailed by the order of the special bench of our honorable court.
It started in 16th June 2024, 16th June 2024, my lord. Charge sheet was filed on 12th of December 24. Without the CFSL report, we have sent the requisitions, we have also followed up the matter. Due to, my lord, there was, the CFSL was overburdened, my lord, that's why charge sheet was, the CFSL was sent.
Hmm.
And on the next, that is on 11th of February,
So how do you
2025.
distinguish this judgment?
This is another judgment.
My lord,
Wait, sir. How do you distinguish this judgment?
My lord, this is already it has been what my lord has stated. It is there's a reference to the larger bench, my lord.
Show us.
That I have to. That I have to-
Why should we do the work only? It is your responsibility. Show us the judgments. Not today. Now
Right.
with the judgment.
Another judgment is there on that.
We acted give copies to those orders you are relying upon. Mr. Chok. Yes.
Item number 4.
It will be there after tomorrow, Your Honor.
Why? She's the petitioner.
Yes,
You are
I'm for the respondent.
State.
State not, NCD.
How long? Every time you are taking adjournment, sir?
Actually,
Actually, not
Report-
actually, we are not answered.
the
Huh?
concern officer
You
will,
clear at your shoot.
my lord, say concern officer,
Twice we have adjourned, sir.
day after tomorrow.
First thing it appeared on Monday when we sat. You took adjournment, we didn't say anything. Next day it appeared, we did not say anything.
Concern officer will come.
Then concerned, it is not his,
Actually,
he is not
He
doing,
put his evidence in opposition, evidence report, so he will come tomorrow.
we will personally call him. If your
I call
officer
him,
does not
I
come.
call him, but he will come from Delhi, Your Lordship.
Although we are very happy to learn that.
So they.
We are very happy to learn that your officer will come from Delhi, court will
So,
wait.
no,
The apex
no,
court of
no, my
the
lord.
state will wait for your
No, my
officer.
lordship. Day after.
Where is Mr. Mojumdar? He said last time, give me the adjournment. And maintain your words. If your officers do not listen to you, you have appropriate devices available.
Day after two.
Don't make them superior to the court. And we tell you, if he doesn't come on, we are not bothered who is the officer concerned. We are bothered about the instruction.
Yes, ma'am.
Day after tomorrow, it's the last day.
the matter for honorable panel of High Court Calcutta.
Tomorrow again, we have to shout like this, that the officer is not.
No, 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 my lordship.
Tomorrow also. On the videography. Let us see later. That is why we remember it was argued by Mr. Vachan. Then what can be done? We'll go to the next circuit. It is your choice. What can we do, sir?
My lord, am I audible?
Yes, Mr. Mujumdar, what is happening?
No, my lord, we have the report ready. Only this needs to be, as your lordship was pleased to direct us, that we should come up with an affidavit. The officer could not reach due to the train movement delay.
So very good. If he doesn't appear, he doesn't appear.
No, my
Mr.
lord, we are
Mujumdar,
filing it today. We are filing it
Tomorrow-
today, in the course of the day, my lord.
You will file it today.
Yes,
Very
my lord. Yes, my
not today.
My lord, kindly keeps it to tomorrow, my lord. Kindly
Pardon?
keeps it tomorrow, my lord. We will
Yes,
file the-
tomorrow we are keeping.
Grateful, my lord.
Yes.
Item number 5.
কিন্তু সেই জিনিসটা কিন্তু সিজারে কোথাও লেখা নেই এবং যেটা কাশিফের জাজমেন্ট কাশিফের জাজমেন্ট বলেছে যে তোমাকে ইট ইজ এ প্রসিডিউর ইন্ডিভিজুয়াল নট অন ইন্ডিভিজুয়াল কিন্তু জয়ের একটা অর্ডার আছে যেটা পার্শ্ব করেছিল সেটাকে ওই ভিডিওগ্রাফি রিপোর্টটা জমা দিয়েছিল না বলে না ওই রিটার্নেবল করে রেখেছে যেহেতু সুপ্রিম কোর্টের একটা জাজমেন্ট ছিল সেটা বলছে এখন তো আপনার কাশিফ সেখানে বলেই যাচ্ছে যে যদি নাও নিয়ে তার অ্যাপ্রোপ্রিয়েট এক্সপ্লেনেশন থাকে
So, item number 5, 6, and 7 all relates to that law point. Whether section 42, non-compliance of section 42, vitiates the trial, and whether the same can be raised during the bail hearing, or the matter is only subject to the trial. Now, it was
my just one submission before lordships. Kindly take the matter one by one, as because 5, the quantum of the fact different, 6, 7 is totally different. Here the matter is heard by, it is item number 5. First, here the matter as because CD and the contention and the search seizures all are different.
Yes.
Some cases the explanation given by the IO, some cases not. So my humble submission, take the matter item number 5, your lord.
Yes.
I'll not enter into the
When was it last rejected, Mr. Ganguly? 2nd December 2024.
This is a part heard matter. On the last week, we have moved this application, and
We wanted to know what
Lordship.
is your explanation in respect of Kashif's order.
lordship. Not only that, I'm grateful that what my lord directed me to make a submission, forgetting that I'm moving the bail application for the accused, but to help assist the court to find out a conclusion regarding what is the present scenario of 42. I'm ready with that. May I take your
So,
lordships to?
Mr. Ganguly, I didn't remember that it was earlier dismissed on 2nd December. So
Not only that, the lordship, the 3rd January also,
before you have labored for that reason,
the
but
bail application.
maybe it has crossed our eyes that it was rejected already.
Lordship,
We were proceeding on the basis as if it is the first time it is coming.
lordship,
Now, if it has been dismissed earlier, then Mr. Ganguly, the question of re-arguing the thing does not have more so when page 10, the order of 2nd December says 42 was considered.
kindly see page 11,
Yes,
para 3, last sentence.
yes, charge sheet is yet.
Now it has been filed. So after getting the charge sheet, the investigation is over and it shows the material collected during investigation, which we could not see prior to that. Now, after going through the same, there are serious anomalies in the investigation, which I would like to place before lordships, from where lordships can find out that the trial itself vitiates.
Lordships, may I invite your lordship kindly peruse the next page, page number 12.
Yes.
Order dated 3rd January 25. Conduct, lordships. Non-appearance on behalf of the petitioner, nor is any adjournment paid for, even in the second call. The matter had been earlier adjourned on 17 December 24, 23rd December 24, and 2nd January 25 respectively. Prima facie, it appears that the petitioner is neither diligent nor serious or proceeding with this application for bail. It is also lordships. So your lordships will found the lordship shows the days. Even
Lordship,
there is.
Yes.
The lawyer engaged was somehow reluctant in moving the application. He was busy in court, another court. So this order, and lordship says not only this, there are several cases where restoration application was filed. Says the same order. It was just the same order made in all the cases. Here it is a change of brief, and that is the reason fresh application has been filed, not a restoration application.
No change of circumstance.
Third January order, see the last line.
Stand dismissed for default. Lordship, it can be considered as because there is a sufficient materials against the question you heard and whatever you want before your lordships. I have the present.
No, whether we are wondering whether we are lost labor. He will also make his arguments, but after this fact scenario, Mr. Ganguly, it was dismissed with an observation that you are not interested.
Lordship, kindly remember, Lordship, 2 restoration applications were allowed by this court only. Subsequently, bail petition was moved. The order says
All
this
right,
same.
tell us what you are showing us.
Lordship, I am not in the case, Lordship.
Show us.
I am on the point.
You do one thing, which judgments you are referring, you please tell us the citations. Then we will first read those judgments, unless
It will be-
wasting your time will not.
Yes,
Lordship, may I hand over those judgments first?
All these
19
judgments.
judgments.
For what?
Lordships, after submitting all
Lordship,
the
this is my case. Please allow me to make my submission.
You make
Why
your
you
submission.
want-
My submission is
doing
you
this?
just cited.
How
before
have
the
you
lordship.
dealt with the last judgment?
Lordship, I am confident enough to my best ability and little understanding of knowledge to place a case that Nawaz Khan not only is non-applicable in our case, but Nawaz Khan cannot be considered by any other bench of High Court in India, as because it is a per incuriam judgment. I'll come to that. Second, Kashif's judgment.
After that, I just submit before.
Kashif's judgment.
One judgment.
Kashif's judgment, where it says that mere technicalities will not allow the petitioner to grant bail. I will try to apprise your lordship that there are 2 types of factual technicalities. One, which is only a procedural defect and can be irregularity. It does not
illegality.
is not illegality, but non-compliance of section 42 vitiates the trial, and as such, it is not a mere technicality. It is a bounden duty of the prosecution to follow the same, as because with great power comes great responsibility, and the prosecution ought to have been acted in a responsible manner so that Article 21 of the Act is not.
Why we should hear you in the backdrop of the fact situation of the case? Maybe dismissed for default,
Lordship.
but there is an observation to that. Yes, exercising our power, we have restored some.
Lordship.
We have restored some.
Lordship.
But we cannot, when section 42 argument was advanced, when it was earlier discussed on 2nd December,
That time,
that the charge sheet was not
not
filed.
there, so,
That cannot be a ground to, you are taking a breather, that now you are getting all the papers,
Lordship.
you are saying this is
Lordship.
illegality.
Lordship, may I?
Why should we, why
Lordship,
should we,
this
why
is an
should we waste
application-
our time?
This is an application.
Charge sheets cannot be change of circumstances.
Yes,
Lordship knows better than us.
Lordship, I humbly submit,
It's a.
complete.
instead
no,
of,
you-
instead
I
of
didn't start
arguing
my
that
submission.
Nawaz Khan is par impodium, that is a very serious allegation which we are raising before this court.
Lordship, I am backed by several Supreme Court judgments on this point.
No, you can understand nothing.
This is academical discussion, but regarding the particular cases, every case has every factor. Factor of the case is totally different. Here the factor, everything procedure fulfilled. So it is nothing but a waste. I can say.
And what is the fact scenario in the earlier cases? Same thing,
Same.
same thing.
Which is
42.
for non-compliance of 42?
42.
So non-compliance of 42. Now, if the charge sheet has not been filed, you could not decipher 42 irregularities.
No, Lordship.
Then,
I'm coming to it. The question raised by my brother colleague is that, as because section 42 point was discussed, but at that time charge sheet was not there. So we did not have the documents, what has been collected during investigation. And after the charge sheet was submitted, because Lordship knows better than us.
which irregularity you found after charge
Regarding
sheet?
42, Lordship,
Which
I
are-
will peruse.
We will get your chance, sir. Wait,
No, just
you
I-
please
I
take
did-
your seat. We will listen to you.
This is an application of bail, not anticipatory bail.
How
So-
long you are in custody?
Lordship in custody since
Yes,
20 July 24.
more than,
yes, about 155 days.
no, more than 250, 225 days.
All right.
My contention is, Lordship,
Hmm.
as because this is an application of 439, not 438.
No, Mr. Ganguly, you satisfied that now what irregularity has been detected
Lordship.
after 2nd of
Lordship.
December 20?
Lordship knows that compliance of 42, delayed compliance of 42 is admissible. Till charge sheet, had they given any explanation of that delay, Lordship would have understood that yes, the delay is satisfactorily explained and it can be taken up. But after the charge sheet has been submitted, the compliance is still non-compliance.
Atu, very good. Tell us what has been written in the charge sheet as regards 42 explanation.
No compliance of 42 has been done.
How do you say that?
I'm coming to it. Lordship, first, sees page 14.
Yes,
That is the FIR.
yes.
From the FIR itself,
Hmm.
Lordship will find
Yes.
that. Lordship, first let us see the section 42.
Yes.
Lordship.
Yes.
Lordship. 42(1). Any such officer,
Hmm.
being an officer,
No, what is the irregularity pertaining to 42 A, B, and C? The irregularity must be pertaining to which is the irregularity you are pointing out? Tell us.
entire Lordship.
What is the entirety? You
I'm coming
first
to it.
show us the irregularity.
First, let us, Lordship, apprise Lordship that what is section 42?
Yes.
Is not information given to the superior regarding search and seizure. It is in 57. Can you see section 57, which says
Yes.
57, Lordship. Report of arrest and seizure.
Hmm.
Whenever any person makes any arrest or seizure under this act, he shall, within 48 hours next, after such search and arrest or seizure, make a full report of all the particulars of such arrest and seizure to his immediate superior officers. So this is the information, the person making the arrest. But section 42 says something else.
You had stopped from arguing that after 2nd of December 24. You are not showing us the irregularity. 2nd December 24, you argued on 42. Now you are taking the stand that at that juncture the charge sheet was not filed.
Charge sheet was not filed.
Yes.
So whether delay communication was
Show us.
now in the charge sheet, Lordship will not find
Yes, what?
any explanation that it was complied with.
Show us.
So the charge sheet. Analysis, Lordship.
What compliance you are wanting? Section 42 compliance. We are compliance regarding which issue in 42? That
42 deals with, Lordship knows better than us, that information received by the officer, diarized, written down in writing, a copy of that has to be sent to the superior.
Yes.
So that the superior is aware of what information has been and what action he has taken or is going to take. It is pre-seizure, pre-arrest compliance. So that the inferior officer, the officer of below rank, do not frame any innocent person in this. The intention of the legislature is so strict on it. It is not a report to the superior regarding search and arrest, as in 57.
yes.
Lordship here, Lordship kindly says, if he has reason to believe from personal knowledge or information given by any person and taken down in writing that any narcotics or psychotropic substance or controlled substance in respect of
That is an irregularity, Mr. Ganguly.
No, Lordship, I'm going to show this is an illegality and non-compliance vitiates the trial.
It is whether it is an illegality or not, we cannot decide at this stage, since on 2nd December this issue was argued by you.
Lordship,
You have argued that even if the charge sheet is filed, in the charge sheet there will be no such explanation, which has ultimately come into papers.
when the charge sheet was filed, no delayed communication was there.
Very good. How was when was the information received?
Lordship, info FIR. Lordship says page 14.
Yes, page 14.
Information received on 20th September 2024. July 2024.
Yes. Yes.
Received the information. And charge sheet was submitted 13 January 25.
Yes.
In the charge sheet, because in the FIR, no copy of what information has been received, it has been sent to the superior. It is not there in the FIR. So, till the charge sheet was filed, there was a chance of delayed communication giving a statutory explanation, as per Colonel Singh. But from the charge sheet, we do not find that part is still in omissions. So, non-compliance of 42 is there, admittedly. When non-compliance, total non-compliance, Lordship. Total non-compliance of 42 is there.
Section 42 says that communication has to be within what time?
Law subsection 2 kindly says, Lordship.
Yes.
Where an officer takes down any information in writing under subsection 1 or records down for his belief under the proviso there
Within 72 hours.
within 70 hours. But
Here
there are
it was
judgments,
not done.
But there are judgments that even delayed more than 72 hours or whatever it is.
So in this case, 72 hours from 20th July.
If we forget 72 hours from 28th July, if we take from 20th July till January, and if that explanation of delay could have been explained by the prosecution, if we take to that extent also, That is also not there
How many persons were arrested in this?
in this lordship. FIR lordship balances page 14. 280 person has been arrested, and in charge sheet lordship says absconding, there is another person absconding, page 25. Total 5 person has been charge sheeted. Rest are absconding. So my contention was that, lordship, I haven't submit to my legal understanding.
This explanation, there is no explanation.
Nothing. Not only explanation, no compliance of particular explanation given. If in case of there is delay, then I could not comply this section within 72 hours because of this. But from July to January, if we take this pen also.
What is your answer to that?
Lordship, first of all, my learned friend submit the 42 is not compliant. Kindly see. And all those matter considered at the time of trial, not at this stage.
Where you are saying?
Lordship, extra.
Margin to decide. This is the informed informed the matter to OC.
So sorry.
So it was informed to the OC.
Yes.
What is the date and time? This is the
Second,
extract of
GD. It's a GD.
No.
FIR is still clear. Lordship.
Where do we find from that?
Lordship from the GD.
Yes, GDN.
Yes, Lordship.
20th July.
Yes, Lordship. It's an arguable case, but this is not a case for bail. Lordship,
সেটা তো করেছে 20th July. Mr. Ganguly, you are trying to say section 42 intimation has to be 72 hours.
Within 72 hours.
So you have shown us page 17, which was drawn up on 20th July. Now your contention is from the charge sheet. There is no explanation as to whether this was when was it intimated to the officer.
Or intimated at all in the process in the manner.
This is the intimation.
Lordship, what is that? What is that, Lordship? I don't know.
This is the intimation which is no, we are not on that. Your topic. We are trying to understand. This is a letter issued to the senior officer.
Lordship.
This was on 20th July.
Lordship.
Then what is the problem you are showing us?
Lordship. What is this? I don't know.
We will go to that. When was the FIR lodged?
FIR lodged, Lordship. FIR lodged on 20th July 24.
So on that date itself, it was intimated.
How, Lordship?
How means what is the procedure?
What is the manner of intimation? Is it GD entry, Lordship?
Extract of copy.
I'm coming to it. I'm grateful to my lord for information.
What you are wanting.
This is a totally illegal procedure, and the Supreme Court last month, a few months ago, has stated that this is not the procedure to do so.
Sure.
I am showing it. First of all, may I place our High Court judgment where my Lord Justice Bishas was one of the judges. Abdul Rakib, kindly sees. আমাদের পয়েন্টটা আমাদের একটু দেওয়া হবে কি আমি অবশ্যই Abdul Rakib, kindly sees, Lordship. Here 42 non-compliant Abdul Rakib 42 was there. Another is there. Kindly sees para 18. Para 18 of
So how it has prejudiced you?
I'm coming.
Para 18 we have seen.
GD entry.
Very good.
Now, state became annoyed of this judgment. No, this cannot be, and they moved SLP to Supreme Court. That this is an illegal order. GD entry is a good order, and 42, as in view of the latest judgment, 42 cannot be a ground of bail. What Supreme Court did
Against this order.
in this order. Against this order, state moved SLP. Kindly see, Lordship, first paragraph. we are not inclined to interfere with the impugned order judgment of the High Court. Accordingly, special leave petition is dismissed.
No law laid down, Mr. Ganguly.
Lordship, the
Yes.
SLP has been dismissed.
Hmm.
The Abdul Rakib, which was referred, is non-compliance of 42 and compliance in form of GD entry, which our coordinate
In the
bench,
facts of that case, it has been done.
yeah, our case also, GD entry they are showing.
We will leave that point open for you at the time of trial.
Now, Lordship. Yes, now, Lordship, if I can apprise, Lordship.
No, Mr. Ganguly, you are arguing an issue. In the backdrop of the circumstances, you have to note. Your conduct has to be proper before us. First of all, whether we can go into the issue at such details at this stage when the petitioner has unsuccessfully approached this court on repeated occasions. This is one thing. You may re-argue this on a better case, better fact. We can understand, but why in this case, Mr. Ganguly? This is sort of a thing is collection of new arguments after fault has been done. Your argument is that the advocate was not properly
No, I'm not with that.
or this point was not argued, it was dismissed for default, but there was finding becomes irrelevant. Finding becomes irrelevant. These things have to be
Lordship,
taken in consideration.
kindly appreciate these two orders, two matters where my lord restored it.
এখানে আপনারা যেটা ফিরে দেখেন বিয়ের হারবার নিয়ম ছিল এটার থেকে বেরোতে আপনাকে বিরোধী ভাবে বলতে হবে ভ্যাকসিন সার্কামস্ট্যান্সেস ডিফারেন্ট ওইখানে এই জিনিস রয়েছে Yes.
Lordship, kindly appreciate one thing. The two matters which came for restoration, my lord allowed
We have
restoration.
yes.
Lordship, kindly, my intention is kindly seize the order, similar order, the comma, the semicolon same. On those matters also.
Yes, we said
It
that
was an order passed by court, the coordinate bench, when lawyer did not turn up. In cases where lawyer did not turn up. Same thing happened here also. Lawyer says the no name of the lawyer even there, and it mentioned lawyer is not there. So he may be engaged in any other court and could not apprise the court. But for
Mr.
that,
Ganguly, tell us one thing. When you approach, there are innumerable instances where the matters are not placed. Why it is not placed? On the basis of an apprehension, this court must reject my prayer. So this you are arguing a very serious issue,
Lordship.
non-compliance of 42
Lordship.
on the strength of a judgment which is difference in the factual aspect. This parlance was not there before the court. The question is, why should we take upon ourselves to answer your arguments in a case where this backdrop cannot be kept aside?
That dismiss for default.
Dismiss for default,
Lordship.
restoration. Earlier to that, 42 argued and set aside. Charge sheet you came to
Lordship,
learn this.
Lordship.
When the charge sheet was filed, prior to that, this GD entry was on record.
How could we know, Lordship?
Very good. You could have appropriately argued before that court that my case was dismissed on without merits. You are now arguing that
Because
without
I did
going
not
into
get
the
the chance
merits. 42 you argued in 2024 December.
2024 December. That
Anyway,
time,
this is your argument? What is your answer to that?
Lordship, in this point, Lordship. But
Yes.
42, I have other issues also.
So according to you, what is your argument?
Lorships, I will. Lorships, kindly consider the para 8 compliance of the mandate under section 37, your Lorships. Supreme Court judgment. Lordship. Now, I have already communicated earlier before start, you open your.
Kasif.
No, Lordship, when I was speaking.
No, I have intimated, which
He took
way
over
I am
from me.
relying before your Lordship. Here, your Lordships, it is clear, a perusal of section 37 of Act leaves no doubt in the mind of the court that the person accused of the offence punishable for the term of the imprisonment of 5 years or more shall generally be not released on bail. Negotiation of bail is the rule and its grant
What
and
was the
exception.
quantity recovered? How much was the quantity?
Lordship, commercial quantity
Commercial
commercial.
quantity from a cart.
from a position your place, Lordship, kindly see the Gadi, Lordship, see the list. Commercial quantity.
It's not a place, it's a car.
Cannot.
All right, you keep the diary with us. We
It's
shall
a
consider
car,
this
Lordship.
with Mr. Ganguly's arguments. Day after tomorrow, এটাকে উপরে to be mentioned রেখে দেবেন.
Lordship is a vehicle.
All right, Mr. Ganguly. And in the other two matters also 42 involvement?
No, Lordship. Rejection, but no question of 42. On other grounds, other lawyers moved. 42 was not taken up on those. And in another no, this is the first time I'm coming.
Lordship,
So in the other two matters, what is your argument?
I'll not enter into the matter, Lordship. Because my lord.
42 compliance.
For non-compliance of 42, how it is, in which place it is going to be affected.
Wait.
Lordship, in the
Wide
the
aspect.
conclusion of the Kasif judgment, your Lordship knows better than us. It is clearly stated, if any irregularities, it will consider at the time of trial,
It's
not.
not an irregularity he's arguing. It is
Lordship.
an illegality which goes to the root of the matter.
Lordship. But here it's,
It is very easy to argue that irregularity, not an illegality,
Lord-
don't touch it.
Lordship, but the.
He is going to the root of the matter that the very inception was wrong.
Lordship,
I may have committed a wrong. It is it is, but you have taken possession of contraband from me. Why this procedure has been prescribed? So that there is no misuse of justice.
obviously, Lordship.
So it has to be considered in that factual background.
Obviously, Lordship.
All right, yes, 4, 5 and 6.
I'm really Kasif judgment.
Day after tomorrow, Lordship.
Day after.
CD,
Everything. Take a
At 2
submission,
PM, at
Lordship.
8 PM এ রেখে দিও।
Lordship, because I want to make a submission to the Lordship.
আবার কি submission?
No. I want to make this submission, which I have prepared, because Lordship told me to assist the court.
Yes.
I want to bring the bigger picture.
No, tell us what is that next point you are arguing? This is on 42.
42, and
Now
and
you
the
will-
thing is 42 in which stage? Because Kasif and Nawaz Khan says is staring at me, but I have several judgments which says no.
I have also.
On different.
I have also
Even-
some judgment.
Even if at all, Nawaz Khan can be considered or not. Even on that point, from 1875 to
Whether we
2025.
would be persuaded to go to that issue is a matter which we'll express in our order.
Lordship.
Express in your order, then only we will, if we are with you, we will hear your subsequent argument. Yes, এইটাকে 20 তারিখে দেখুন। You have given us copy of that, what you are doing.
No. Okay, will I take it and once again give a?
No, please retain with us
Oh,
so that
Lordship,
we can
Lordship,
go through it.
That is Abdul Rakib, which SLP was done.
Yes,
was
yes, my
rejected.
brother will also go. through.
Lordship. My Lord Justice Bishop pass this judgment.
The case diary আছে না,
Yes,
hard
yes, that
Mr.
is brief, Lordship.
Uh-huh.
My brief also handed over. to-
ওই brief ও hand over করে দিস তাহলে। আচ্ছা, hard Mr. Ganguly learned advocate appearing for the petitioner. We have Mr. Sarkar, learned advocate appearing for the state, has placed before us the case diary. Stop, let the same be kept on record. List the matter for further consideration on day after tomorrow as fixed at 2 PM.
Lordship.
Deeply.
Next,
Deeply.
4, 5 and 6. 4, 5 and 7, all right.
5, 6 and 7.
Oh, sorry, 5, 6 and 7. তাহলে ওই অর্ডার করে দিও। পরের দুটোতেও সেম অর্ডার করে দিও। ও না, দেন 5 and 6 টা জাস্ট ওটার সাথে ট্যাগ।
CD টা আমার দেবেন।
We shall take it upon.
My lord, CD was printed, na? CD.
Yes, we have written.
Lordship.
Keep the city.
No, not your CD. Your CD is not written. 5 you take, if you have anything to show, you show it. Yes, next.
Not in 8 I have written.
Yes. এখন চেঞ্জ অফ ল whether is factual or speculative, আমরা বুঝবো কিনা in the light of the subsequent judgment delivered by the matter of trial সেটা কিন্তু আপনার সাথে মৌসুমী যেটা হয়েছে মৌসুমী ওটাকে ঢুকিয়ে দিয়ে দিয়েছে সেটা যেটা আপনাকে সরে আসতে হবে এসএলজিটাকে ডিসমিস হচ্ছে সেটা কিন্তু একটু বের করতে হবে আপনাকে কিসের বেসিসে এটা করবে একটু দেখুন। Yes.
Milord. Milord, in this matter, altogether, Milord, 3 persons had been apprehended by the concerned police station. And Milord, my specific point here is that it is not the case of the prosecution that the alleged contraband materials were seized from the joint possession of these 3 accused persons.
3 accused.
3 accused persons. Now,
3
Milord,
persons are before us.
only one of them. I am for Rupahas Tamang.
Yes.
My lord, one of them is before your lordships. Now, my lords, kindly takes up page 9, the FIR. The first para itself.
2 petitioner.
Oh, yes, my lord. I am for 2 of them. Yes, my lord.
Rupas and Nikanor.
Yes.
Yes.
Rupahas and Nikanor.
Yes.
Now, my lord, it says the first paragraph itself kindly reads from the 4th line onwards. The following seized articles. The words following seized articles. Number 1 light green colored sealed envelope containing 1 liter real fruit powered orange juice, orange rich in vitamin C, containing 1 liters of codeine phosphate and tripolidine HCl syrup, Anirex. According to the statement of the car driver Nikanor Lepcha, recovered from the backside pocket of the driver's seat, cover kept concealed condition marked as Exhibit A. So this contraband, my lord, was recovered as per the statement of the driver of that particular car. Now, my lord, kindly takes up 2 thereafter. 1 light green colored sealed envelope containing 3 bottles of codeine phosphate and tripolidine HCl syrup, Anirex, each bottle containing 100 ml syrup, 1 bottle having batch number such and such. This was seized, my lord, from my possession, the petitioner number 1. Hence, my lord, the FIR has...
Just yes.
So, my lord, the FIR as well as the seizure list at page 13, my lord, at page 13, 1-3,
Yes.
kindly takes up point number 3. It basically reiterates what has been written in the FIR,
Page 13.
page 13.
Yes.
Point number 3, from whom seized. It says item number 1 recovered and seized from the backside pocket of the driver's seat cover of Alto car number SK04P1917, kept concealed condition. This was recovered for as per the statement of my lord Nikanor Lepcha. Now thereafter comes item number 2, recovered and seized from the right half pocket of accused Rupahas Tamang, and item number 3, which is the car,
Yes.
was
What
again.
is your argument?
My specific argument is that, my lord, the prosecution themselves have segregated the possession. It is not their case that these contraband articles altogether have been seized from our joint possession. As far as the first possession, as far as the first contraband is concerned, my lord, which is the 1 liter real fruit juice bottle, that has
was
been
on the statement of the driver.
of the driver, as well as it was on the back side of the driver's seat. Hence, my lord, conscious possession cannot be attributed to me, Rupahas Tamang.
Yes.
I may not be pressing the application for the driver, my lord, but for Rupahas Tamang,
Who was
it is
the driver?
Nikanor Lepcha,
That is petitioner number 2.
petitioner number 2.
Yes.
At this stage, my lord, I am not pressing for petitioner number 2, but petition number 1, my lord, Rupahas Tamang, from him 3 bottles which were for his personal consumption. However,
Yes.
intermediate
Any
quantity
other
was seized.
point? Any other thing you want to show?
This is my argument in crux.
Yes, what do you
My
say?
lord, though it has been segregated, but serial list containing the three accused persons itself, my lord. This is the serial list.
No, we
Also in the serial list, my lord, categorically mentioned the items we are recovered from the separate persons, but containing three persons' signature, my lord.
That may be there.
no, it was recovered
My lord, as
on
per
the from the that from a card.
from a car. From a car back seat of the driver back seat, my lord, 1 liter and 3 bottles recovered from the half pant pocket of the accused Rupahas Taman, petition number 1. This is the all about the serial list, my lord, but contains 3 persons' signature.
Contains?
Three arrested persons' signature in the serial list.
Mr. Shah learned advocate reading for the petitioner. One liter.
1 liter is the commercial one.
So
3 bottles.
Three bottles contain
300 ml.
300 ml.
then it is above commercial.
No, my lord,
No, no.
300 and 1 liter is 1000.
Oh, 1 liter. আচ্ছা
Yes.
আচ্ছা কি বললে? Shall learned advocate appearing for the petitioner submits that contraband substance below commercial quantity was recovered from the possession of the petitioner number 1 hearing. And from the back seat of the card, that is also commercial, or
That is commercial quantity.
and
1 liter.
and was recovered from the possession of the petitioner number 1. And that as such, the regards of section 37 of the NDPS Act are not attractive. The petitioner has already suffered detention since 3rd September 2024. 3rd September, and upon completion of investigation, charge sheet has been submitted. In view thereof, further detention of the petitioner may not be necessary. Mr. Acharya, learned advocate appearing for the Mr. Acharya, learned advocate appearing for the state, however, disputes the contention of Mr. Shah and submits.
Mr. Ghosh, my lord.
Sorry, Mr. Ghosh, sorry. ওপরে Mr. Ghosh করবো, নাম্বার কাটা যাবে। Huh?
Mr. Attorney learned advocate for the state, however, the completion of Mr. Ghosh.
No. Drawing our attention to the Caesar list, Mr. Acharya, learned advocate appearing for the state submits that from the same place and on the same date and on the same date and time, contraband substance above commercial quantity was recovered from the petitioners and another.
Petitioner,
3 persons.
Petitioner, including 3 persons. Total 3 persons.
From 3 persons, including the petitioners here. Stop. The total quantum of commercial
1 liter, 300
contraband
ml.
substance recovered is above commercial quantity. In view thereof, the statutory restrictions are clearly attracted. We have heard the learned advocates appearing for the respective parties and peruse the
For the petition.
Yes, yes.
My lord, the allegation is that contraband was found from the possession of the petitioner. But the fact is that he boarded a aircraft from Mumbai airport and landed at Bagdogra airport. At the time of when he was boarding that, his baggage was scrutinized. He was allowed to board the aircraft and to fly.
Yes.
And his baggage was checked in baggage. And after
You have argued that when it was last rejected on July 24th. What
My
is
lord,
the
my lord.
difference thereafter?
My lord,
Again rejected on 2nd December 20.
my lord, there are other points are also.
What other points are there?
There was no.
What is the change in circumstances after 2nd December?
My lord, there was no independent witness also, which is only the CIFS personnel were present. All the circumstances are showing because he was not.
It was there before you when you argued.
My lord.
That was on 2nd December, it was due.
My lord, my lord is not bound by that order. I'm humbly praying to listen on merit, my lord. Because
We have hardly learned advocates appearing here, appearing for the respective parties and consider the materials on record. Records reveal that the petitioner's application was earlier rejected twice by coordinate benches of this court on 23rd July 2024 and again on 2nd December 2024. Prima facie, we do not find, we do not find any change in the circumstances subsequent to dismiss last rejection of the petitioner's application for bail on 3rd December 2024. Accordingly, we are not inclined to exercise discretion in favor of the petitioner at this stage. Application dismissed. Yes. Item 10.
Item number 10. For the petition.
Yes. Which for the state?
The allegation is of recovery of below commercial quantity.
Below commercial?
Below commercial, 12 kg of gaja. From
what is the commercial quantity?
20 kg, Milord. The allegation is that
you are in custody since when?
96 days, Milord. Since
charge sheet submitted.
Charge sheet submitted, Milord.
Yes, Mr. Sarkar.
Exclusive position, Lordship.
Intermediate quantity.
Charge sheet file.
Ashok. আচ্ছা
It's not received, my lord.
তো বেঁচে গেল তাহলে, নট টুডে।
Item 11, my lord,
হ্যাঁ
is Khoribari police station, my lord.
হ্যাঁ
Every time they are doing this, my lord. Several times we communicated with the with mail, phone, but they are not responding. But kindly make an order, my lord.
Heard Mr. Poddar, learned advocate appearing for the petitioner or petitioners.
Personal clearance of the IO is required.
Petitioner.
OC of Khoribari police station, my lord. Every time Khoribari, only Khoribari police station is not cooperating with us.
Investigation
So
over.
ask your
Yes,
PP.
ma'am.
Investigation
Yes,
over.
We don't know, my lord. We don't
Well,
know.
I have instruction charge sheet submitted.
Yes, Mr. Chakraborty, two Chakrabortys.
Khoribari police station take করছে প্রত্যেকটা।
My lord, will
You are not being tough. You are not being
No,
tough.
my lord, one day, my lord, I'll.
Take appropriate. Then if you cannot, we will take. Not today. Yes.
Well,
I want the state.
Again, Mr. Poddar. Bad case.
Very bad,
Even a bad case.
very bad.
Very-
on the basis of statement of Coacus, one Coacus granted and bail by this honorable court, my lord, I am standing on the same footing.
Yes, Mr. Bhattacharya.
My lord,
He's
commercial,
saying same footing.
no, commercial quantity of heat. Other 6 anti-incident is there against that petition. Yes,
Against that petitioner.
yes.
Oh, ওটা আমরা ভালো করে পাস।
125 bottles of cup syrup.
Not from me, my lord. On Purshit Sarkar,
And he is the
I am custody about 138 days, my lord.
dedicated member of this racket, my lord.
আচ্ছা 148 days.
Yes, my lord.
You are in custody.
I am in custody.
And your name has transpired
On
on.
the basis of statement of Coacus.
আচ্ছা on 140.
And he was charged in another 6 number cases. Same.
Six
Yes,
cases.
yes, my lord. This is the memo of evidence, my lord.
তাহলে আর কি করবো?
My lord, my humble submission.
You have not been convicted. You have not been convicted in that.
Not. This pending. One Coacus
The
granted.
charge sheeted accused, my lord, in another 6 cases.
Mr. Poddar, Natagan.
Here, my lord, mere antecedent not bar. Kindly see.
One antecedent we could have considered, 6 antecedent.
On the basis, one thing, my lord, practically, it's some person names transfer one page.
And a charge sheet is pending, my lord.
I am submitting, my lord, 1 minute, my lord. Sometimes there
We are
is,
giving you 2 minutes.
my lord, there is a enmity created, many times, my lord, fully personal implicated. There is no other material, there is no CBR, there is no bank transaction, nothing, my lord. Only on the basis of statement of Coacus, my lord. I have custody more than 140 days, one Coacus granted bail by your contact. There is no other intimating material. If I apprehended one case, there is an enmity created, police implicated many cases also, my lord. This version cannot be ruled out, my lord. If you lordship kindly see, one of the judgment. my
My lord, kindly see,
দাঁড়া, wait,
my lord,
judgment.
kindly see the page. Oh,
31
There is no CBR, no bank transaction, nothing.
not only that, he is a charge sheeted accused in another 6 cases.
There is no intimating material came out, my lord.
How you are connecting him with the offense, Mr. Bhattacharya?
My lord,
You are drawing nexus on the basis of what? Apart from coercive statement, do you have any other?
no.
That is,
In
charge
this
sheet
case,
is
the statement of the
charge sheet, investigation has not completed. as-
no, my lord. It is a premature stage of investigation.
No, he has already suffered incarceration for 148 days.
Oh, my lord, he has pre-incident. He is the,
We understand, but how, when are you going to submit the charge sheet? 180 days, na?
my lord,
So today 150 days has gone.
another. We had- As per the provision of law, my lord.
হ্যাঁ, হ্যাঁ। Your only argument is, apart from the co-accused statement, there are antecedents.
Yes,
We accept.
And
your-
charge sheet has been filed against.
We
that
accept you as a charge sheeted witness. In this case, we are wanting to know from you that what is the, apart from all these things, what is the nexus? Any fresh material has been obtained? To that, your answer is investigation is continuing. So when you are going to complete the investigation?
In a very short period, because of the, when we received the official report, then we can able to file the charge sheet.
There is no implementing mechanism.
Other accused persons were enlarged on bail.
One who has granted bail by your lordship, I handed over. He is in custody, my lord. I will cooperate with the investigating agency. There is no chance of my PC period also.
Mr. Poddar, learned advocate appearing for the petitioner submits that the petitioner's name has transferred on the basis of co-accused statement. Co-accused statement, and as such the statutory restrictions are not attractive. Considering such issue, this court has granted bail to a co-accused. Yes, next.
Item number 30.
Yes, sir.
Item number 39. My lord. Kindly see the page number 10 of my application.
Anybody, any other person has also filed application? This has to be your application. Yes.
My lord, kindly see the page number 10 of my application, the formal FIR. Formal FIR is lodged against one Ropijul Mia. There is no mentioning of other accused person's name. Subsequently, in the FIR, we can found that There is 4 FIR named.
Wait, in the, what did you say? In page 10 is the
Page 10
FIR?
Page 10 is the formal FIR.
Huh.
My lord, there is only one person's name has been stated.
Rapiju.
Rapiju.
You are Rapiju.
No,
Motion.
I'm not.
Motion
for-
Sarkar.
I'm for motion Sarkar. Who is the motion Sarkar? My lord, kindly see the FIR, page number. There is 2 vehicles. One is Bolero pickup van bearing number WB 63A 2117. And another vehicle is WB 64 R 5966. I am the passenger, co-passenger of the vehicle.
Where did you get the vehicle? One,
My lord,
two vehicles.
no, my lord, I am not the owner of any vehicle and I am not the
Ada,
driver
ada,
of
ada,
any
ada,
vehicle.
ada. কি নাম্বার বললো কোথায়?
Page number 13, my lord. Page number 13 of my application. Para number 2. Middle part.
Bolero pickup, after we saw the suspected pickup vehicle bearing registration occupied by one driver, another whiter color Bolero
Yes, ma'am.
occupied by 3 persons.
My lord, on same para, last third line.
Yes,
A secret chamber of the pickup vehicle bearing registration number WB 63A2117, which was driven by the accused Rafizul Mia. Entire contraband article was found from the conscious possession of said Rafizul Mia, and even in the seizure list, page 20 of my application, seizure list, there is a note part. There is a note part where it is clearly stated that recovered from the pickup truck bearing registration number WB 63A2117. It is crystal clear, my lord, that entire contraband articles were seized found from the secret chamber of pickup van, which was driven by the Rafizul Mia. And this incident.
and then you are one of the 3 persons who were there in the Bolero.
Bolero.
In the Bolero, no seizure was
No
made.
seizure was made.
So,
And with, at place of arrest is a toll plaza, my lord. Panipuri toll plaza. There was another vehicles also there.
so why your vehicle was pulled up?
My lord, in this context, I am stating that this petitioner actually came from the Mundibari towards to Shiliguri. And this vehicle, Bolero vehicle, which was owned by one
Bolero,
Uttam Chandra Narayan,
you are not the owner of the other one.
I
You
am
are
not
only
the
a
owner.
passenger
just a passenger. Being a passenger,
in a private vehicle.
private vehicle, my lord.
Huh?
I am a passenger of a private vehicle.
Then how did they link you
They stopped the
to toll
vehicle.
plaza?
They stopped the first vehicle, pickup Bolero, pickup van. And my vehicle was just beside the.
Your vehicle was the Bolero.
Yes, my lord. Passenger vehicle. This is a passenger vehicle. And pickup
No,
van
no,
is.
you were in the Bolero vehicle, no?
Yes, ma'am.
Pickup was being driven by that person.
That person. Rafizul Mia. whose
So
name
why
is
you are
stated.
saying passenger vehicle, Bolero?
My lord, that means pickup van is for transporting the goods. And Bolero vehicle is for the transportation of office uses and for several use.
Bolero te মানুষ যাবে আর pick up এর material. So that is exactly what you did.
No, my lord, no, my lord, no, my lord. There is crystal clear.
That is
Sorry.
exactly what you did. You are sitting in another vehicle.
No,
Let
my
the
lord, I don't know the other accused persons, my lord. I was a worker.
Now custody, how many days?
My lord, I'm in custody since 80 days.
80 days. Charge sheet submitted. Yes, Mr. Acharya.
My lord, this is the seizure list. From whom column 3 from whom is all the 4 accused persons names are there, my lord, and also signed by the 4 persons. And my lord, in reply of the same, my lord, kindly see the flag pages, the CDR, which shows this petitioner and the driver of the Bolero pickup are there, my lord. The flag pages. This is the seizure list, and flag pages is the CDR.
From whom seized? From conscious.
Name 4 conscious position of 4 accused persons.
Acha, where is that you have stopped the vehicles?
the toll plaza,
Panikori told.
Panikori toll
There
plaza.
were two vehicles,
Yes.
there is no doubt.
Yes.
Now, on that, you are showing CDR.
CDR, मतलब the flag pages, मतलब.
When was the
The
CDR?
Bolero pickup are leading the Bolero pickup van. This is the petitioner herein, Mausam Sarkar,
So he was having a conversation with
with
the
the driver of the Bolero pickup.
So when it was toll plaza, when it was stopped, time was
Time malad.
Instructions is at 9:30 hours.
9:30 to 13:20 at night. Na, দুপুরবেলা. So when was this telephonic conversation?
Same day, malad. Prior arrest.
Call date 25/11,
There was matter.
30/11.
Same day.
Conversation was 25/11.
No, no, no. This continuing page, malad. Kindly see. বলছি তো। 30 তারিখ আছে তো?
27/11. 27/11. 30/11.
And this vehicle was accompanied by with the followed by the Bolero pickup van. Both are intercepted together. Moreover, my lord, the seizure list containing 4 persons signature and from whom is column, kindly see the seizure from the 4 accused
So
persons.
that you will do, you will stop the vehicle, what will they, if you are
The
in.
telephonic conversation, my lord.
On
Huh?
the
Delivery
same
cost,
season
That
list,
is,
last page, there is a note part, my lord. That enter report from the pickup truck.
If this petitioner does not know the driver of the vehicle,
that you have,
telephonic
that
conversation.
if it had been one or two, we could have understood. Investigation continuing.
Investigation pending, your lord. Still pending.
Come after some days. Ask Mr. Learned advocate appearing for the petitioner submits that the petitioner is Not today.
Item number 16.
Yes, who is in 16 states? Yes,
This is my one of my fail application.
when what is last rejected?
This was some members electoral 14 November 2024, page 8 and 9.
First of
14 November, page 8.
It was rejected by all them and this year charge sheet was also not submitted. Another thing, Madam, charge sheet was submitted. Madam, in this case, Madam, quantum was not required from me, Madam.
not recovered from you.
Not required from me, Madam. Prosecutor story that
You are Dhaneshwar.
no, Madam. Dhaneshwar was enlarged from granted bail by your lordship regarding the order, Madam.
No, all right,
Madam, I am.
then you are
Your name is Sunny.
Sani Thakur.
If your lordship kindly see case 13 of my application. If that.
13. Yes,
But in this case, in immediate portion, if you are saying on spot interrogation, they disclose their identity as stated above, the detained lady, Timothy Bobita Roy, where the she and her husband, Sani Thakur, procured narcotic substance from Dhaneshwar Burman, alias Chotku, of Uttaranand, such and such. This is the implication, my lord. 3 persons arrested on the spot, namely Bobita Roy, Bolai Burman, and Mohammad Samsed Alam. 3 persons arrested. And a confessional statement that Bobita Roy, that
what were the 3 persons you said?
3 persons, my lord.
That is,
Bobita Roy, Bolai Borman.
where you are reading?
Page 12. Page 12. 3 persons.
No. Independent,
Page 12.
13. Oh, Bobita, Bolai, and Shamshed. They were arrested. Now the detained lady Bobita
Yes.
revealed that she and her husband procured narcotics on Dhaneshwar.
Yes.
Dhaneshwar given bail.
By you. This is on the basis
Sani
of-
Thakur is the husband of Bobita.
Yes.
Oh, achha.
Husband is Bobita, my lord. And there is proof-
So there was recovery from Sani Thakur.
No.
He was not at this spot.
No, not at this. Not at this spot. After some
My lord, para 3 of the rejection order, kindly come to para 3 of the rejection
Judge.
Yes.
Detained lady of Bobita was arrested. Bobita said, my husband has procured those from Dhaneshwar. She and her husband.
Husband procured from Dhaneshwar. This is statement of boy.
Where is the Caesar list?
Here is the civil list, my lord, page 19.
Achha. Yes, this is the point. You are in custody for
I am in custody about 160 days.
106 charge sheet submitted. Submitted.
Submitted.
Yes, Mr.
My lord, I have only 2 points, my lord. One is the earlier rejection order, my lord. Kindly come to paragraph number 3. The house from which the recovery was made,
Earlier rejection date.
date of
Page
the
8 and 9.
14/11/2024, page 8 of his petition, my lord.
Page 8 and 9.
Page 8, last paragraph.
Last paragraph, page 8.
Yes, my lord.
Primary
Privacy
civil
we found.
the house from where commercial quantity was recovered was rented out by the landlord to this petitioner.
Lordship, this is the constructive position of the petitioner. This is the ground on which this earlier bill was rejected. And there is a criminal attitude.
Ganesha also criminal antecedent, he was in last one bill by the lordship. The order should also get. Investigation is in progress.
No, Dhaneshwar is not similarly situated.
Now,
with you.
No.
my humble submission, my lord. My humble submission, my lord. There is no physical position. At that time, I am not at the spot. There is no secret. There is no secret so that I am giving all these conventional statement, my lord. At this juncture, charge sheet is not yet filed, my lord. Charge sheet filed, my lord. There must be a physical position also, my lord. Without physical position, my lord, only it cannot be said this is conscious position, my lord. My humble submission.
Acha, Mr. Where do you have this document in support of that? He was residing as a rented house.
This house from which the recovery was made is a rented house.
But
At that point of time, when Bobita was present in the house with these other two accused.
now Bobita said that I and my husband used to collect drugs from
Yes,
another.
He said.
From Dhaneshwar.
From Dhaneshwar.
Now Dhaneshwar given bail. And that means his connection is.
Sorry to interrupt, my lord. In this matter, item number 18, which is of another query.
Oh,
And,
yes, I was there.
Oh,
Or
that
Yes, madam.
I'm in that case, my lord.
you are Bolai.
There is
He is
no-
Bolai. So Bolai, from Bolai it was recovered.
Found all these three accused persons, my lord, goes to the Caesar list. my lord.
No,
Caesar list is
Bolai
page number
Bobita.
19. It's written that it was recovered from a rented house. But there is no specified that from home position it was required. It was from the joint position. Three were present. It is page, my lord, the Caesar list, page 19. It is clearly stated.
Who was the tenant?
Tenant, as per the FIR, Bobita was this tenant. When Bobita stated that I along with my husband Sunny, we used to collect these brown sugars from one Dhaneshwar of Paribari and we used to sell it. Because a certain amount of money, a huge amount.
This Sunny has any antecedents?
Sunny has that antecedent in this case, my lord. Sunny had.
Sunny had.
Ganesha also has been same case. Ganesha I have given the order sheet. Your lordship also observed. Your lordship also observed. Ganesha also.
আমি আর আমার হাজবেন্ড ওটাই কালেক্ট করি। This is the nexus.
Dhaneshwar was granted bail, my lord, as because it was the name came. Dhaneshwar's name came from the version of the co-accused. In that case, nothing was recovered from Dhaneshwar. That was
Same here. Nothing recovered from Sunny.
Caesar list, my lord.
Caesar list from the house of Bobita. He was a tenant.
Yes, Anita too has a criminal antecedent of NDPS. So that is there.
Now,
Dhaneshwar did not have criminal antecedent related
no,
to
madam.
NDPS.
No, Dhaneshwar also.
No, madam. Dhaneshwar didn't have.
Yes,
This is the Sunny Thakur.
Sunny Thakur had.
Who had?
Dhaneshwar
Had criminal antecedent, but not connected to an NDPS.
Dhaneshwar.
just took over one. And actually Sunny Thakur. Just were also involved in connection with everybody case number such and such. Under section, section,
Sunny is there in another matter.
NDPS matter.
এইটাতে 16/7
Yes, Sunny.
হ্যাঁ 16/11/2024
Everybody case number, এটা হচ্ছে 234 and everybody case 234 2020.
হ্যাঁ এটা হচ্ছে পরিবারী
Yes, case, the 170.
he has an antecedent.
Earlier antecedent, co-accused granted in NDPS case anticipated bail. This case charge sheet submitted. Only statement of co-accused. Kindly see, my lord. Charge sheet submitted, my lord. In some occasion, charge sheet not submitted. Investigation, giving investigation. I covered charge sheet. I detained in custody, my lord. Co-accused statement, no other incriminated. Only allegation of antecedent, my lord. Being detained in custody.
Mere antecedent, not denial of bail, my lord. Charge sheet in this case, my lord, charge sheet submitted. my lord.
Where denial of antecedent? কি
My lord,
বলছে?
in this case, my lord, and there are several judgment also, my lord.
অনেক আছে না?
Yes, my lord.
ও,
My lord, in this case, my charge sheet submitted, my lord. Earlier case, my lord, charge sheet not submitted, my lord. In this case, charge sheet submitted, my lord.
কি দিয়ে দিছে?
I cooperate with the trial, my lord.
We have not asked you to do so. If we reject your petition, you will cooperate. What is your?
Mitigation.
If we reject, question of cooperation does not arise.
My lord,
Mr. Shahabodar, you have not gone through the earlier rejection order.
Why it was what was said?
I must not say this. In NDBS case, there is nothing called a constructive position. The position has to be a conscious.
Constructive possession is a
Constructive
legal
possession of the
fiction.
house.
It is a legal fiction. This has been termed by the court. We have said so that on the basis of legal fiction, it is construed as conscious possession. Mr. Poddar, learned advocate.
my lord, my humble submission, my lord.
Please, please, let
Poddar,
him talk,
learned
please.
advocate. Mr. Poddar. You go.
Charge sheet submitted, my lord. In this case, there is no other intimating.
Mr. Poddar, learned advocate, appealing for the petitioner submits that the petitioner's name, the petitioner has been falsely indicated and his name has transpired on the basis of co-accused statement. There was no recovery of contraband substance from the petitioner. And there was no recovery of contraband substance from the petitioner, and as such, the statutory restrictions are not attracted. He further submits that co-accused persons have already been granted bail, and the petitioner has already suffered detention for more than 168 days, 60 days. Stopping view thereof, further detention of the petitioner may not be necessary, since upon completion of investigation, charge sheet has been submitted. Well, which is the next bail application in Mr. Chakot is there? That is Bolai was physical.
And for Babo.
Yes,
Actually, if your,
it was with the
your lordship, take a look at the scissor list,
Uh,
column 5. This three transparent packets.
Three transparent brackets.
It was seized from where? It was seized from the house of Bobitara, kept inside the almirah of Bobitara. Now, I was at the wrong place at the wrong time. Nothing was seized. No money was also recovered from me. I was only present there and nothing else. From 24th July, I am behind the bar. I am a local resident of Jalpaiguri.
What is your argument to that, Mr.
Only
Chakoti?
that effect is there, nothing more.
Regarding my lord, but my matter number 16, my friend stated that
He was there.
Bala is the principal accused.
No,
It is
no.
his sub, no, I'm just coming. Here, my lord, all the three accused persons from whose position the articles has been seized, they were within their knowledge, they are the principal accused, all of them. Bala is one of the principal accused. Videography has been done, my lord. The entire proceeding was taken into videograph, my lord. We have the copy of the videography.
Mr. Chakoti, the presence. What can be that animus? He was the wrong place, wrong time he was.
That is his submission.
No, we are submitting, suppose any person. Your nexus is on the basis of that you were there at the spot. That is why you are you are the principal accused, recovery was done in your presence.
There may be two reasons also, my lord. The court can hold that either he has came to purchase the contraband articles or he has bought the contraband articles from Gariwat to deliver it.
In that
Two
case,
things are there, my lord.
We have heard you.
So here,
আসো, এটা কি বলুন? We have Harding, sir. কি বললেন? When was it last rejected? When, first time? You are in custody for
24th of July, I am.
কতদিন হলো?
One year, not first. Charge sheet has been filed within on 17th of January 2025.
7 months.
You have not approached this court earlier. This is the first application.
Yes.
My lord, his stand is different from Sunny, my lord. My lord, in case of Sunny, has my lord has finally actually
Who
find out that
accused?
in the Caesar list his name is not there. So Sunny may be arrested later, my lord, whatever it is. He may be the husband of Babita.
Hey,
But here, my
wait,
lord,
wait.
you know,
আগেরটা থেকে his name does not feature in the Caesar list. ওই বোদ্দারের পেনশনে ঢুকিয়ে দেবে। দিয়ে দিতে হবে। বলে ববিটা রূপ টুকরেও দিয়ে দেবে।
exclusive joint position.
How it can be exclusive, Mr.
As per the Caesar list, my lord, it's written exclusive joint position.
But it is from, oh, it is not from the house.
Yes,
It's
not
from
only
the
from the house, from the Almira of Bobita. Now what's kept inside an Almira?
Where from do we find that?
From the Caesar list, column number 5, it's clearly written. Shall I read?
Column number 5 of the Caesar list.
Yes,
Where do you have annexed?
Page 40. Description of seized articles.
না পুরোটা পড়তে হবে না দাদা, just my lord, from Roman 2 above third line.
Roman, that is
Ah.
money.
Indian and above third, just above the third line, my lord, inside the Almira of the
Oh.
house.
Car mobile হচ্ছে। আসুন, and advocate deputy for the petitioner submits that
Commercial quantity.
Not today. 18,
Item number 19, as of statement.
19, yes.
My lord, I am for the petition, my lord. The offences are under the NDPS Act. My lord,
একটা ওকে একটা লাইন ঢুকিয়ে দিতে ইট ইজ নট এ কেস দ্যাট দি ও কোথায় গেল সেটা where is the petitioner this is your first application in item
Yes,
number
your lordship.
হ্যাঁ item number
18.
ওই 18 এ ওকে আরেকটা লাইন ঢুকিয়ে দিতে হলো ওর কন্ডিশন দি petitioner it is not a case that the আমার ওই হার্ডের পরে it is not a case that the petitioner in numerous prior rounds emerged in numerous prior rounds they had emerged enough reasons to believe that the petitioner was prima facie guilty of the accusations তারপরে yes this one
Item number 19.
so my lord, the prosecution case in nutshell is that they had a source information that some contraband was about to be transported. Lord, they ambushed near a petrol pump, and when this petitioner came with a truck, Lord, he was apprehended, and Lord, the contraband was recovered from him. My lord, charge sheet has been the entire search and seizure, my lord, has
you are
been.
the driver
Yes, my lord. Allegedly, I am the driver. My lord,
you are Kalam Sheikh
yes,
sole accused
sole accused. Now, my lord, the entire search and seizure was conducted in the petrol pump in presence of two independent witnesses who are the employees of the petrol pump. Lord, charge sheet submitted. Now, my lord, two witnesses being the seizure witnesses have been examined as PW1 and PW2. And my lord, I'll be placing that before your lordship. Saurabh Das. Yes. My lord, may I read it for you, lordship? But he says, I work at Shiv Parvati service station at Shitkabari under Nishiganj outpost and Mathagala police station. About 6-7 months ago, I was on night duty at petrol pump with Surojit Devnath, and during that time, one truck came to our petrol pump. Subsequently, some police vehicles also came there. Police searched the vehicle. I signed on a paper as produced by police officer. This is my signature on the paper, which is marked as Exhibit P/1. I did not find who was driving the said truck or who was in the said truck. Cross-examination. In night, our petrol pump also open where police vehicle come and obtained our signature in a paper. I cannot say for what purpose and when I signed on the paper. I cannot say the contents of the paper I signed. Lord, next PW2. Almost similar version, Lord. Surojit Devnath. He also says, I am working at Shiv Parvati service station at Shitkabari under Nishiganj outpost and Mathabanga police station. About 6-7 months ago, the incident took place when I was on night duty at petrol pump. And during that time, one truck came to our petrol pump. Subsequently, some police vehicles also came there and had talked with the driver of the truck. I signed on a paper as per request of police officer. This is my signature on the paper, which is marked as Exhibit P/1/2. I cannot say the contents of the paper on which I signed. I did not find the driver of the truck for which I cannot identify him. Cross-examination, I cannot say for what purpose and when I signed on the paper. I cannot say the contents of the paper where I signed.
yes Mr. Shalkam
One more
submitted
yes. One more thing. These two were the seizure witness. This is their version. They have not talked anything about the seizure and they have not even declared
you are in
hostile.
custody since when
I am in custody since 234 days. Well, since 31st of May 2024. 10 prosecution witnesses, Miller, 2 have been examined. And these are the 2 witnesses. Lord,
yes
since-
Mr. Shalkam
Perceive the evidence is going on. And rest 8 witnesses remain still. And at this juncture, it is not possible to come to the conclusions to prove the case, your lordships. And lordships, here I am submitting to your lordship that the huge quantity of brown sugar, that is 919 grams of brown sugar, near about 1 kilogram of brown sugar and 21 grams of Yava tablets. And lordships, just few words before I hand over the place for judgment. That even 5 years in this particular case of 37, bail is exceptional, your lordships. And here maybe they managed the 2 witnesses, they may hostile, but rest witness is
Not
still.
hostile.
No, no, not. Obviously, but remain 8 witnesses still. So at this juncture, it's a very
You did
premature
not
stage.
get the owner, you did not get the owner of the vehicle? Have you got the owner of the vehicle? Did your officer take steps?
Perceives,
He was the sole accused.
he has a
You,
sole
too- you should have ascertained the owner.
perceive as
Is
because
there anything there in your,
other evidences.
what other evidence?
And how it will be come to conclusion he is not the owner of the vehicle. It will maybe come later that and evidence is still going on. At this juncture, is a very initial stage. Commercial
You yourself has said that he was driving the vehicle.
Lordship, but if someone, as because Lordship, just 2 witness already done. Rest,
They are the vital witness. They are the witness to the
maybe
seizure witness.
all the witnesses are vital.
They are the witness to the seizure. Don't forget. They are the witness to the seizure.
All witness Lordships. And maybe they have managed these 2 witnesses.
Nothing is there.
No,
That
no,
is that
Lordship,
you cannot go beyond the record.
He is the hostile witness and not cross. That is different aspect. The trial court PP not declared as a hostile witness. I just received this as because we are not the advocate of the trial court. I received. But in this situation, he should be cause the evidence as a hostile and cause the witness. So some maybe there is another scope is there, your lordships. 37 is one huge quantity brown sugar. Lordship, my
Come day after tomorrow, take instruction.
Lord,
You are
one,
disputing this fact
Yes,
that
Lordship.
whether he has been declared hostile or not.
no, Lord, certified copy is
declared
with
as
me,
a
Lord.
hostile.
How he can be declared on the said date? What is the procedure?
On the same
On the same day. They have to be declared hostile.
Yes,
and
Hostile and they, the prosecution caused the hostile
so,
witness.
Lord, no prayer has been made by the prosecution.
And Lord knows better than us, it's an organized crime. Lordship. And Lordship, the passive judgment is clear in Lordship. Ideas, it doesn't matter. Here only just furious. And the evidence is part, not only the, out of 10, only 2 is correct.
Who are the other witnesses? They are the Caesar witnesses,
Police
Mr.
witness.
Sarkar.
But my lord, others of the gazetted officer, others, they also maybe.
Are they
give
were
an
not on
opportunity
the
to
spot.
them to.
They
and
were
because
not.
They are not such a innocent person. My humble submission before your lordship. If they enlarge on bail, it will impact on the society. This is not my submission, your lordship. Judgment of the Honorable Supreme Court, your lordship. Not to take.
Already you ascertain why not declared hostile. Come day after.
That portion already gone as because they can again recall the witness. That can be done.
And many things can be
Yes,
done.
boss.
They
Then
can
you-
recall the witness and declare him as hostile. Is it the procedure? What
No,
kind
why
of
your
submission you are
things are sufficient?
That is different thing. Another charge sheet witness are there.
So,
Come,
taking that advantage, such type of.
I am sorry, I couldn't declare you hostile. কি করবো?
Lordships, I will take instruction. I will take
What,
instruction.
what kind of instruction?
The Arjun Jogdiji landed advocate appearing for the petitioner submits Or argument the certified copy of the, you give a Xerox of that just.
I have given Lord, one certified, one zero.
ও তাহলে ঠিক আছে।
Grateful.
Item number 20, I'm praying for not placing this application for non-prosecution.
On the prayer of the learned advocate appearing for the petitioner, comma, the application is dismissed as not placed. Yes,
My lord, I am for the petitioner. 21C, my lord, 21C of NDPS Act. My lord, only recovery 120 bottles of cough syrup from the house of the co-accused Sofiul Haq. My lord, kindly see the seizure list, column number 2.
you are in custody since when?
My lord, I have custody since 3rd September 2024.
Charge
One,
sheet submitted?
no,
Not-
my
not
lord,
yet,
charge sheet
madam.
not submitted.
Not.
160 days. 67 days, my lord.
Caesar list what you are showing?
My lord, kindly see the para number 2, the house of the Sofiul.
FIR.
My
FIR,
lord, not seizure list.
where it is? Caesar list এখানে নেই?
My lord, I have certified copy.
We don't.
I did not annex.
Oh, ওটা যত্ন করে রেখেছো কেন?
Malad, this is the serial list. Kindly see the, from whom since.
In the house of Sofiul, my lord.
তিনজনের থেকে চলছে।
Only signature was taken.
Joint possession of- Where you are getting that from the house in the Caesar list?
My lord, column number 2,
House of Sofiul.
Sofiul. I am, my lord, I am M. Kumar. M. Kumar Sethi.
Where it is stated in the FIR that it was in the jointly
My lord,
at the
firstly,
house of Sofiul.
house of Sofiul. I am not Sofiul.
You are what?
I am M. Kumar. M. Kumar Sethi, accused number 3, my lord. It is only joint possession, but not physical possession.
হাউস থেকে পেয়েছে আর কি, ওরা রেখে বলছে কনসিলিং হাউস অফ দেখুন।
My lord,
You were concealing that. Your place of concealment was the house. How can you detach that from you?
my lord, kindly see another aspect. My lord, the section 52A subclause 3 also violation.
That is a case to be considered at trial. Mr. Such and such learned advocate.
My lord, kindly see the house of the Sofiul, not my in physical
You
position.
were concealing, that is the allegation.
My lord, only allegation. It is my
Is
only
that
allegation.
Being that the petitioner has been falsely implicated. Falsely implicated, he has already suffered incarceration. Yes, 20.
Allegation is of recovery of 7 kg gaja below commercial quantity, my lord, from 3 lady petitioners. And my lord, I am in custody for 37 days. And my lord, your lordships, in a separate case, my lord, in similar circumstances, there was custody of 30 days. Your lordships were pleased to grant.
We have even given in 15 days.
Charge sheet not filed. CS charge sheet not filed, very
Very
initial
good.
stage of
Caesar list. Caesar list.
lordship.
My lord, in my petition,
Look.
page 14, my lord.
What's that?
So position from given position, exclusive position.
Is it below commercial?
Yes, Lord.
Lord.
Only then 37 is not applicable.
But the charge sheet not filed very,
Hmm?
only 37 days.
Lord, any stringent
You are,
condition.
you are thinking of acquiring after that.
But after submitting charge sheet, my lord considered all the bail below commercial quantity. No.
Your lordship, in another case, my lord, there was no charge sheet. On 30 days, your lordships were pleased to grant.
Having heard the learned advocates and having heard considering the materials on It can be, we cannot disturb the list at this juncture. Yes, sir.
Grateful, my lord. Automatically
Today is 59.
What can we do, sir? Bail application.
Tomorrow at any time,
Pardon?
tomorrow, let it be fixed tomorrow at any
Leave
time.
your other side.
Yes, my lord, other side, Mr. Pradeep Sarkar and Hirok Burman,
Item number?
59. WPS.
We cannot assure you, sir. We will try to upgrade the mentioned matters. Let us see how you proceed. Who is your other side in this?
Other side, Mr. Hirok.
So how
Burman.
you will understand that you are mentioned?
No, my lord, I have informed him. With consent.
Yes, call the list. Or write it a note for us. Yes. 25. Yes.
My lord, in this matter, I am appearing for the petitioner, my lord. The affidavit of service is here, there. My lord, it is indicating item is dispatched, but delivery is not indicated.
Not today. Not to. Yes, next.
My lord, the affidavit maybe.
No, keep it with.
Obligement. Oh.
My lord, regarding my lord, item number 36, regarding the anticipatory bail for the juvenile, my lord.
Diploma.
Actually, I have brought those citations, my lord, so.
Today you have
It's
brought.
fixed at 36, my lord.
Who is your other side?
No, other side.
Item number 26, I bring.
Let it be called
My
Mr.
lord.
Chakraborty. We will take the judgments and what did you find? Is it
My
being
lord, there are
pending?
3 judgments. First
Is it pending before larger bench?
Yes, yes, my lord.
Large judgment
Large judgment is pending. There are 3 judgments. One judgment was there, my lord. My lord, in one of
difference of opinion at the বিভিন্ন High Court. But the 11th High Court থেকে একটা গিয়ে সেটাকে ওরা একটা large judgment form
actually, in one of the judgments.
Let it be called on
My
Mr. Yes, item number 20.
I'm praying for one day.
Why, where is your senior?
Because Lordship, advocate on record is just late.
Day after tomorrow. Or let it go before the next bench.
Day after tomorrow, Lordship.
Day after two. Yes.
Yeah, for the petition.
Yes. Who is in 27?
Ganguly. Pass over the matter.
Then we pass over. Mr. Ganguly is there.
My lord.
Pass over. Yes, next.
Item number 28.
Yes, next. 28.
What's that for the petition? What's the one day accommodation? Day after tomorrow, so please.
Day after tomorrow.
What's the thing is that learned council Sudip go have to leave the court for some emergency
Yes,
reasons.
next.
Item number 29.
Yes.
Lord, I am for the state.
Which for the? Yes, 20. Tell us what is the matter.
Well, this is the third application. Twice my application for bail was turned down by this honorable court.
Yes. Tell us.
My lords. My lords, the rejections orders are in page number 8 and 11.
What are the sections?
My lords, 302, 201 of the Indian Penal Code.
Where is the last rejection?
My lords, it's in page number 11. 4th of November 2020. And it's the prosecution case is
So what is the change in circumstances?
my lords, till date charge has not been framed. And lordship, I'm not the principal accused as per the prosecution case.
You are not the principal accused.
I'm not the principal accused. And it's on the leading statement of the principal accused, that is Mokbul Mia, the dead body of the deceased recovered. And my case is that there is no allegation. If your lordship kindly sees the 164 statements and the last seen witness, nobody has uttered my name. Entire allegation is against Maqbool. And upon the statement of Maqbool, the prosecution has got the dead body and the case has been initiated. Whereas I am in custody since 28th of April 2024.
2024.
My lords. And charge sheet was submitted on 26th of July 2024. And my lord, next date for framing of charge is on 22nd of February 2024. 25.
22nd February.
2025. And my lords have seen that the last observation, as because the charge was not framed, my application was turned down. And my lords, there is no observation on the merits of the case. I take your lordships through Dr. Chaudhary to seize the circumstances against me. I'm not the Mukti.
My lord, from the observations, from the observations of the coordinate bench, my lord, the coordinate bench has meticulously gone through the materials in the case diary, my lord, and past observations for rejecting the application for bail. My lord, this petitioner was last seen with the principal accused, and my lord, thereafter, my lord, this lady was murdered. My lord, headless body was recovered. So, my lord, at this stage, my lord, it is not conducive, my lord, if he is enlarged on bail. Since the vital witnesses are yet to be examined, my lord.
Yes, there are 21 witnesses in the charge sheet, and there is no scope to tamper with the witnesses. And my lords, kindly, my learned friend has said that I have been seen with the accused persons.
That has been observed. That has been observed in the earlier order.
That's true. But I have to brought the facts before your lordships.
No, page 9.
My
The court has observed
my
that.
lords, my lords. My lords, I am not on that. Kindly considers the custody. I will not leave the jurisdiction of the local police station. I will meet the officer in charge of the police station.
It is said by the learned advocate on behalf of the petitioner.
Who is there? Yes.
Item 30, I am paying 1 day because my senior is coming tomorrow giving matter before your lordship.
Not today.
I don't know what.
My lord, I am for the petition. My lord, the offence is under section 302 of the IPC. My lord, I am in custody, my lord, for 863 days now, my lord, that is 2 years and 5 months approximately. My lord, 9 out of 13 witnesses have been examined. And my lord, the eyewitness is the PW9, my lord, I have annexed the certificate. I have, my lord, certified copies in your lordship's brief. My lord, the last page of my brief is the PW9. Lord, he is the eyewitness, my lord, he has Lord, adduced evidences with respect to the situation, Lord, that has happened there. Lord, Aman Thapa, PW9.
Who is the accused?
Lord, I am the
Bal Bahadur.
Bal Bahadur
When
Bade.
was it rejected earlier?
Lord, first application.
First application?
Yes, first application. May I read it, Lord?
Yes.
Yes.
My lords,
Who is the principal accused?
sole accused.
Sole accused?
Yes.
You are in custody for?
My lord, 2 years, 5 months, my lord. 863 days. Lord, 9 witnesses have been examined, Lord.
So it will be concluded.
Five more.
When is the next
20th February 2025 for the further evidence. 20th February.
That is further evidence of next week.
Next.
Now, my lord, in the cross examination, but considering my
First time is substantially progress হয়েছে এই বলে reject করবে।
my lord, considering my prolonged detention in the matter, in the case, and also the fact that the eyewitness narrates the incident, saying that it is the deceased.
Come after some time.
Lord, 2 years,
Yes,
5.
next. You know.
It is read by the non-literate.
Defecto. Who is petitioner? Who is petitioner? Nobody.
So,
Day after tomorrow, yes.
Lordship, praying for not today. Item number 34.
Why do you bring the matters in the list if you don't want to do?
This is that juvenile matter.
Next Sunday, why?
No, no, it 34.
Sorry.
Under 36, what I mean, yes.
34, yes.
Kindly, Lordship, not
Lorships,
today.
my submission is your lorships. The bail matter already considered by your coordinate earlier bench. Ramalabakshi and others. And there is a, give a direction to change the IO. There is a lots of proceeding and lots of latches and lacuna. IO has been changed recently. And again, they have filed a bail applications. So just a few days before the bail applications turned down. by your
What do you want?
Lordship, I just 2 days accommodation is because I want to know who is the second IO appointed IO and all these things. Murder case here. There.
Not.
Next circuit or something.
Next.
Maybe it were Thursday or Friday. If Thursday might not.
We don't know whether you will get.
No, Lordship, I will collect as because previous I have gathered that earlier just.
An adjournment has been prayed for on behalf of, on the joint prayer of the parties, the matter stands adjourned. Is the matter for further consideration before the next available certificates. Yes.
Item number 35.
35, my lord, I am for the state, my lord.
Lord, I am for the petitioner. Lord, this is that matter concerning the Lord missing documents from the Office of the Assistant Engineer of Joyga Development Authority.
My
Lord, in the last
My lord
occasion,
wanted the investigating authority to file a report, whether it's cooperating or not, my lord. Here is the report, my lord. I abstain from reading over the report, my lord, since the investigation is going on. The last 2 paragraphs of the report, my lord, is my submission.
Oh,
Lords, may I just peruse the report, Lord, once?
Just a moment.
Yes.
Confidential.
Lord, there was a direction to meet the IO.
He made the IO, the rest is there. Lord, one more thing I would like to make, my lord. These are not ordinary files, but I have in the FIR I have pointed out 2 files, my lord. My lord will realize these are not ordinary files. These files involve huge amount of document relating to huge amount of government money, my lord.
You only for your perusal, don't keep any copy on.
Yes,
Return it.
Yes, Lord.
These are the files are very important. This is the tip of the iceberg, my lord. We need him for custodial interrogation. Huge amount, these are the projects, huge amount of government money is involved, madam.
But this diversification of the fund,
there is no.
This diversification of the fund, that is answered now, because the money which was spent, he had no access to it. It was done by the project which was shifted.
My lord.
That amount of money which was there that he has not he's not involved in that.
My lord, we cannot specifically say that at this stage, my lord. Let the investigation proceed, my lord. We need him for custody. Until and unless these files are recovered, my lord, the investigation will be stalled. We requested him, he met us, but he didn't cooperate, my lord. We have a videograph of the entire interrogation process, my lord. My lord,
I've seen the report, my lord.
so there is a need for custody.
It says, my lord, that he maintains his stand that during the relevant period, he was on leave, firstly, my lord. After rejoining duty, my lord, he has approached the authorities that his office has been kept locked. Pursuant to an order of this honorable court, his office was, my lord, reopened in the presence of police officers as well as officers of this court. After that, these files were found missing. What they are trying to impute on me is, my lord, a diversification of certain funds, which I have showed to your lordships on the other day, the previous day.
That is one.
Yes,
There are
my lord.
26 projects involved.
26 projects involved, only the files, my lord.
Yes.
The files,
So what
those were
happened-
not in, my lord will
Those
kindly
were in the
appreciate.
chamber.
In my chamber,
Yes.
in my chamber, which was kept under lock and key for 3 months during my period of leave, my lord.
My lord, page number 29 and 30, my lord, will make the entire thing clear.
Without blocking to like that.
These are centrally locked, my lord. These are centrally locked offices. My lord kindly takes up.
The anti-corruption is also holding a parallel inquiry.
My lord, what is happening here, my lord?
It's happening.
Why are they
26
trying to impute everything on me, my lord? When all the tenders, all the work
When you are in
were under.
when you are in custody of certain documents, it
Yes,
is
my lord.
your responsibility to keep it safe.
Yes, my
And
lord.
you went to the High Court also. High Court said so far as the missing files are concerned,
Yes.
you take necessary steps.
Yes.
On the basis of that, they have proceeded.
Yes, my
Now they want to see those files which have gone missing. You cannot throw yourself outside the arena saying that what files I do not know. It was not under lock and key. Who has taken it? I do not know.
No, my lord. I am saying that for the 3 months that I was on leave on, this office was kept under lock and key by the authorities.
No,
Kindly seize that, my lord.
my lord, 29 and 30
For-
page number will clarify this.
My lord will kindly take up, my lord, the
Two
relevant pages.
statements are there.
The period of my leave kindly takes up, my lord.
Page 29 and 30.
So kindly let me finish.
Page 29
And 30, my lord. Two statements.
Page
two
133
statements are
of my
there.
application, my lord.
29 and 30.
Page 133 of my application, my lord.
Page 29 of the CD, my lord.
Page 133.
3 of my application.
29 and 30, my lord. These are the custody of the relating to the
Yes.
custody of the
Yes,
key.
Ajay, wait, sir.
Last.
Huh.
The subject is request for urgent action to remove unauthorized lock on office chamber. This is, my lord, 21st of October 24. It says, sir, I would like to bring to your notice that on 4/10/2024, I had submitted a request to lodge an FIR regarding an incident where an unknown person had unlawfully locked my office chamber at the Joyga Development Authority. This chamber contains several important office files and documents. Today, upon rejoining my office duties, I found that my chamber is still under lock and key, and I am unable to access it. This has caused significant inconvenience and has hampered my ability to carry out my responsibilities. Therefore, I once again request you to kindly take necessary action to remove the unauthorized lock from my office chamber so that I can regain access and continue my work without any further delay. This sufficiently explains it, my lord. Everything is happening behind my back, and they are trying to shift all the burden on me. Things are happening behind my back, my lord. My lord, kindly considers this. Lord, I seek to place, my lord, 2 judgments of the Honorable Supreme Court as regards custodial interrogation. Just 2 judgments. Confidential.
Confidential, that's fine. Copy on.
Lord, the relevant page is page 12 or para 23. Page 12, para 23, 3 million.
How it is recorded by the investigating officer, 161 statement, what language has been used?
Bengali, my lord.
No. Not being.
Take it and read, take it, look.
Lord, page 12, para 23, 3. It says it is imperative for the courts to carefully and with meticulous precision
evaluate the facts of the case. The discretion to grant bail must be exercised on the basis of available material and the facts of the particular case. In cases where the court is of the considered view that the accused has joined investigation and is fully cooperating with the investigating agency and is not likely to abscond, in that event, custodial interrogation should be avoided. A great ignominy, humiliation, and disgrace is attached to arrest.
Yes.
Arrest leads to many serious consequences, not only for the accused, but for the entire family and at times for the entire community. Most people do not make any distinction between arrest at a pre-conviction stage or a post-conviction stage. Now, my lord, I happen to be a family man. I happen to be the assistant engineer right now suspended me. Assistant engineer of this particular authority. I have a particular standing in the society, my lord. Kindly do not direct my custodial interrogation. That should not be the ground to, my lord, reject my bail. That is, my lord, one.
It is for the sake of investigation, sir. And High Court has directed them free hand to conduct the investigation. Why didn't you prefer appeal against that order?
My lord, against
you High Court, you approached. High
Yes,
Court passed an observation.
Yes,
On
sir.
the basis of that, the entire episode has begun. It has been reopened. You did not seek it necessary to challenge that
I did
direction.
not challenge it, my lord, because I was ready to cooperate with them from day one.
Sorry, sir.
I
you are-
complied with the order, my lord. Kindly take some, my lord, another judgment. Kindly
And
take.
say, surrender,
it will-
obtain, come for bail.
It will be, my lord, kindly do not direct my custodial interrogation. It is not necessary in this particular case. I am seeking reliance on another judgment where the, my lord, offences were under 467, 468 harsher than the present case, as well as the Prevention of Corruption Act. The Honorable Supreme Court says, but kindly takes up this. This is from the year 2024, my lord.
সাইটেশনটা বলুন কপিটা দিল
In this case, my lord, the offences were under 467, 468, as well as the Prevention of Corruption Act. What does the Supreme Court say, my lord? Kindly takes up the second page, para 12. There is no gainsaying that custodial interrogation is one of the effective modes of investigating into the alleged crime. It is equally true that just because custodial interrogation is not required, that by itself may not also be a ground to release the accused on anticipatory bail if the offences are of a serious nature. However, a mere assertion on the part of the state while opposing the plea for anticipatory bail that custodial interrogation is required would not be sufficient. The state would have to show or indicate more than a prima facie case why the custodial interrogation of the accused is required for the purpose of investigation. But what have they been able to show? As per your lordship's order, I have joined an investigation. I was kept in the police station for the entire day. I had fully cooperated. I maintained my stand, my lord.
Yes. What
As regards, my lord,
that is in the report, my lord. The serious offense, my investigation will be seriously prejudiced if I cannot recover the file.
But kindly
His
grant.
assistance is required.
We have heard
Yes.
His assistance is required, my lord. He was given an opportunity. He didn't cooperate. There is a videography, my lord.
He will cooperate.
Where
He
is the
says
file?
that I am not responsible for missing of the files.
My lord,
What you want to extract from him?
my lord, what you want?
He has said that I am not, I was on leave, I had no control over the files, etc. It is not in my possession. So then he is making a false statement. Now in
My lord.
custodial interrogation, what he will do?
Custody interrogation is necessary, my lord. It is necessary.
Why? Why necessary?
To extract more information, my lord.
What information? About the files?
About the files, my lord. About the files, my lord. It is necessary, my lord. Otherwise, my entire investigation will suffer.
We will kindly consider this, my lord. Kindly considers everything is happening behind my back. But they are afraid that
We have heard you. This way a matter is not argued.
I'm very sorry.
Tenders were granted in favor of his
Sir,
wife.
how you are conducting investigation? You are saying 26 files of different projects had gone missing.
My lord.
So how that is concerned with this case? You can implicate him. You can implicate him if you get a relationship that he was the in custodian of those files. Now, this question was who has put the lock on the room. It is a disputed question of fact. It is a question of investigation.
Lordship.
You are saying that for that his recovery is required. Now, what were the files? What is the linkage with him? Nothing.
The tenders were given in his wife's name, my lord.
Lord, again.
Right, oh.
Which
Okay.
tender?
Corruption, there is another part, Lordship. Tenders were given to.
So show us that.
My lord,
It is not a part of the case,
it is with the corruption, my lord, give us 1 day time, we'll bring that document also.
My lord, I'll clear
That
that
is
form.
not a part of the
Separate,
case.
corruption is a separate wing of police that they are investigating the anti-corruption charges.
I see. Yes, show us that.
My lord, I'll clear that form, my lord. It is there in the record itself.
28th,
My lord, kindly grant me 2 minutes, my lord. I'll show your lordships.
You want us not to see that file?
No, my lord. I'm showing it to your lordship. That file. It is in the record itself. It is in my petition, my lord.
Let him produce the document.
Yes, sir. There is sufficient explanation in the petition itself. This tender that they're talking, which was, my lord, awarded to my wife.
All right, day after tomorrow.
My lord.
Did the
Let me report me with the record, my lord.
My lord, day after tomorrow, I may not be available, my lord. Kindly takes it up tomorrow.
Tomorrow I am not
I have a flight day after tomorrow, my lord. I won't be
Tomorrow I
available.
am not available. That is why I prayed for day after tomorrow. My lord.
Then what can be done?
My lord, as regards this allegation, my lord, it is there in the record, my lord.
We want to see the file, sir. Do you have any problem? But if we want to
I have, yes, but I have a prior engagement, my lord. Day after I'm leaving for, my lord, Jabalpur.
Next
Extremely
circuit,
sorry.
my lord. Next circuit.
Kindly extends my lord interim protection.
The interim protection was for a limited purpose, my lord. Now there is.
Lord, kindly
no
extend my
interim.
interim protection. If this application is kept pending, my lord.
very good.
Lord, they may,
He will hear day after tomorrow. He has produced.
Lord,
the
day
report.
after, my lord, I will not be available. That is
What can
that
be
is my
done?
prayer.
Don't put us in an embarrassment situation.
Lord, kindly
You are
takes,
putting us in an
kindly
embarrassment.
adjourns it till the next
Keep it
circuit.
that day. Keep it that day. I'm going there. I'm coming here.
This is
How much we can accommodate?
this is my only prayer. Kindly adjourns it till the next circuit, my lord. Extends my
No,
interim
sorry.
protection.
No, sorry. That we cannot do. No.
Lord, day after.
Or we say we keep it tomorrow. If you get those files tomorrow, please make an attempt. And if not, we will consider.
Tomorrow, my lord, then tomorrow, in
We are
first few
keeping-
matters, my lord, because I'll be leaving tomorrow. Then first, if it is placed on first few matters, it would be easy on my part.
Very good.
At 10:30.
First 5 matters, within first 5 matters, if it is, the matter appears, it would be very easy on my part.
Yes, not today.
Okay.
An adjournment has list the matter, let the report, as filed on behalf of the state be kept on record. So list the matter for further consideration on আজকাল কত তারিখ? On it. The petitioner shall not be arrested in this meeting.
Complete blockage.
Yes, next.
Item number 36, that matter already referred to the larger bench, your lordships. And last hearing held on your lordships. And next date has been 10th January and fixed matter 3:15, but thereafter nothing has been recorded.
Then what will happen? He will
Matter is
sub
judice, larger bench.
But this is a prayer for bail, anticipatory bail.
Anticipated.
He is a minor.
Yes.
So don't arrest him.
Similar matter, Justice Showmanship observation.
That was in favor of the.
It was not allowed. He was sent to the board.
Lordship, after that, I did on 23rd September judgment, where the minor has been granted anticipated bail.
23rd.
No, September.
Larger bench gets it. Where is it is pending before the larger bench, which judgments have been sent?
CRM 2739 of 21 year actually.
Paragraph number 13. There were two petitioners here. Petitioner number 1 was major. Petitioner number 2 was juvenile.
So very good, that case.
However, we would not wish to aspect better as the larger event has been constituted to resolve the issue and also the right of juvenile to approach High Court participable is pending before the Honorable Supreme Court. We dispose of this application directly the petitioner want to ensure presence of petitioner to the board within 10 days from date. So that means his anticipated was not granted as per section 12, the board has the exclusive power to deal with the juvenile.
And what is the contrary judgment to this?
This contrary judgment was, my lord, passed by first, my lord, in our circuit bench. There was a case in 2021 where I also appear on behalf of the state. This is the judgment where Honorable Justice Harish Tandon and Vivek Chaudhary passed this judgment.
That is
in favor that anticipatory bail will lie.
Order date.
Then Mr. Chakraborty, what will be his remedy?
Thereafter, my lord.
Now, what will be his remedy?
Thereafter, my lord, justice, this is the another judgment. This is of the principal bench passed by Justice Arijit Banerjee. It's a division bench judgment, my lord, this one. Here said he no, we differ from the judgment which was passed by Justice Honorable Justice Tandon, and they have passed that anticipatory will not lie, and they have referred the matter to the larger judge. So this is the scenario. After that, in 2020,
what is your contention? That
my lord, this should not be allowed. They should, sir, because if they approach there, as per the law, they are entitled for bail. So they will be. It's not that they had any apprehension of arrest. If they don't have any apprehension of arrest, why anticipatory bail will be guaranteed? If there is no apprehension, the apprehension there must be a genuine apprehension even in cases, my lord.
Why you're saying there will be no apprehension?
Because he will not be arrested. He is juvenile. He will produce, if he approach before the court.
He may appear before the juvenile justice
court, my lord. Yes.
Get bail.
Yes.
Question of bail.
No question of arrest.
There is a difference of opinion before the High Court expressed different opinions. That's the matter was pending before the large Supreme Court. And a large
even the last
during the pendency
last
of this judgment, I have relied on 18th September judgment.
What is your problem, sir? What prejudice you will suffer? If during your intent is so that you are not arrested, that is your intent. So when you can get that protection from the juvenile board, why you are highlighting today in view of this fact situation, larger bench is insisting. Either way, direct it will be in favor of one judgment. So in the meantime, you approach the juvenile justice board, get the protection.
But Lordship, I have the right to file the anticipated bail.
That right we will consider. That right is that has not yet formed because it is for larger bench is in sitting.
So during this pendency of this judgment, one of the coordinate bench allow the anticipated bail.
May have allowed, but in view of the conflicting decision, what advantage anticipatory bails means you will not be touched till conviction. You are a juvenile admittedly. There is a procedure prescribed. What is the process? Anyway, we cannot give you another version. What is your contention? Tell us. Will you surrender before the juvenile justice or you will come here? We have when the larger bench is ceasing, as in this judgment, you are given the liberty that go and approach the juvenile justice.
Go there and take bail.
You get the remedy.
But the coordinate bench already granted one of the.
Coordinate bench is hierarchically down than the larger bench which has been constituted.
But it was not
the issue,
But the same issue does not decided on the apex court.
It's pending,
It's pending.
Yes.
So during the pendency of the time,
you go and surrender. You go to the juvenile justice.
But the same issue has been decided earlier.
Who is your senior? You are appearing in this matter. You have a senior. You don't have a senior. You argued last time. Talk with your client, sir. And if you insist that we have to pass an order, we will pass an order. Day after tomorrow. Kartik, maybe keep retain the orders. Maybe retain these orders.
Yes, yes.
Ascertain, sir. Ascertain, if you want, if you want on this, then if part chance we hold against you, that will again create a problem. Huh?
My lord, thing is that actually the Juvenile Justice Act, why the section 12 is there? Because he has to appear before the board, and if he is under 16, automatically he'll be granted bail. If he is
he will be
18 and
taken to the
16
home.
That's
is
why.
the problem.
And that's why they have. But home for what purpose? The purpose is for his counseling, my lord. He requires counseling if he has done a crime.
Consider and come. Yes, next. Yes, 37. Who is the state? That's yes, tell us.
My lord, allegedly, my lord, cultivated. Lord, allegedly, my lord, cultivated poppy plant has been, my lord, recovered from one Kabir Sheikh, elderly person, my lord. He has been arrested, and my lord, during his custodial interrogation, my name has revealed that I am one of the, my lord, the associate who, my lord,
Land belongs to whom?
land belonged to Kabir Sheikh. Nothing has been, my lord, found from my possession, no cultivation, nothing, my lord.
Liaquat Sheikh. Who is Liaquat Sheikh? Liaquat Sheikh. You know Liaquat Sheikh?
And one, the quantity is, my lord, one.
Yeah.
Lordship. Father of the
Yes, Mr. Chokut. Charge sheet submitted.
No.
Charge sheet not submitted. The land is in name of Liaquat Sheikh with the father of the principal active. I have produced the Khatiyar Manor, the ROR.
That is principal accused.
Father of the principal active.
My lord,
Kabir Sheikh.
Kabir Sheikh, my lord. Kabir Sheikh.
This is Sabul Kia. My lord, another thing is that statement is on page number 20.
Page number 20. For what recovery above commercial?
My lord, 1 kilo, my lord.
Commercial.
Copy with 1
Commercial. What is the commercial?
Copy store, it's 18B now. So
The cultivation.
it's a cultivation.
Along with soil, my lord.
Should not be considered.
My lord, it has been stated in the FIR.
So how do you ascertain?
The quantity, my lord, it's in the act, my lord, NDPS.
The quantity when it will be ascertained. After taking it from the plant, you will do it. Have that been done?
Check them.
My lord, soil.
His name is in the
18B, C is not there, C is, I think it's not commercial.
It is, হ্যাঁ সেটা দেখেই বলছি।
18B.
18 beta to commercial bond. 18 beta.
And my lord, the soil was also wet.
Where the conservation in the soil. No.
18.
Contravention. Contravention involves with punishment. এটা তো 27 apply করবে 37 will apply. Now provided what is the quantum? Oh, দেখে আসেন.
1 kilowatt.
It has been destroyed. Ultimately, it has been destroyed.
One of the land has been recovered along with soil. That has also been stated in the FIR.
Contravention involves this agent 17B, Mr. 17B. Where contravention?
The prepared, yeah. Cultivation.
Poppy straw
18.
seems to be poppy. With 1 kg, some soil from the pit with 1 kg.
Separate, 1 kg and 1 kg. But Caesar, this is page 9.
1 kg and
1 kg soil and 1 kg poppy straw.
so what is the commercial quantity? Poppy straw? You should have checked it out. When you start doing the matter, you open your books.
150 grams. The one is, this is a commercial.
Much above commerce. Charge sheet has been submitted.
Has not been submitted. The
This
case
is
of
the case of January 15.
Investigation going on.
Very initial stage, madam.
Cultivation করছে land ও case of acquisition.
This two-bit sheet, my lord, has already been transferred bill by the land.
Statement দেয়া আছে.
Where is that?
That is subsequently happened. That is subsequently.
Sure.
Bring that over.
Not today, you should have said that first. See how you waste time. People are mentioning it from the morning till.
Yes, I have not been.
So if you're not holding, say that I am not holding. You're unnecessarily taking your chance. When you now saw that the court is maybe a bit different, I will produce that. Don't junior members don't misuse the conduct of the court. It irritates us. I'm being lenient to you. That does not mean you can sit on my head. You would become more lenient that when the court is with me, I can make the argument, I will produce that. This simply irritates us. Yes, next. 15 minute wait হয়ে এখন বলছি। দাও দাও পাস টু বার
First one matter item number 27.
কত দূর ডাকলে
37 দেখেছে।
এইটা ডেকে শেষ করলে
38 আর পড়া আছে 38
কে পাসওয়ার্ড হয়েছে ওইটা দাও দিয়ে ডেকে দিয়ে চলে আমরা Yes.
Initially, FIR was registered under section 302. Subsequently, after conclusion of investigation, charge sheet has been submitted under section 304 of the Indian Penal Code. Proceed the petitioner, and the allegation is this: on 22nd of October 2023, the aged person Dilbahadur Rai and his wife, while sitting inside sleeping inside a room, their daughter, their son, namely Osim Rai,
Anup Rai.
Osim Rai, their son Osim Rai barged into the room after having been drunken condition, and subsequently started to hit on his father, and the father immediately shouted, and other people had called down and many people gathered into the house, including the petitioner himself. And immediately petitioner tried to rescue the father, and also an altercation took place. During the course of altercation, a hit was inflicted upon the deceased.
He inflicted.
Yeah, the petitioner inflicted hit upon the assaulted the deceased
So
also.
you went to fight on favor of your father and hit your father.
No, my uncle. The deceased is the uncle of the petitioner.
Oh, deceased is the uncle.
Uncle of the petitioner. So this assault was done at the spur of the altercation, and that is how he succumbed to death immediately. Lordship, immediately the petitioner was taken into custody and investigation was carried out. So everything was, the petitioner suffered 5 days remand, police remand. Subsequently, he was kept on judicial remand. Charge sheet has been submitted. 207 document has been supplied. Now the petitioner is in custody for 460 days. Now the best piece of evidence against me, that particular initial victim, who is the father of the deceased, whose name is Dil Bahadur Rai, who has stated against me, and this is the best piece of evidence.
Who is the deceased? Dil Bahadur?
Dil Bahadur is the father of the deceased. Dil Bahadur is the father of the deceased. The deceased initially primarily assaulted his father, that means Dil Bahadur. Now Dil Bahadur, when shouted for rescue, and immediately petitioner entered into the room and he rescued him and his wife.
Who is the complainant?
Complainant is one Salim Subba.
She is the
Salim Subba is the local people who lost the complaint upon basis of the hearsay evidence.
Yes, sir.
Lordship, as the 161 statements were recorded in Nepali, I translated the two of the important 161 statements. That is the Dil Bahadur, father of the victim, and the mother of the victim. They have seen the occurrence.
And who is the complainant?
The complainant is the local people.
Deceased Oshim, deceased son was whenever you come to usually to have dispute with the family and whether he would leave the home in the morning because so he said, I have no idea as to usually after doing down you come and try নিজের টাসের পেপার সব তো ছেড়ে দিয়েছে and really is way to wait he and he took the interview I was reading all my grandson which he quickly arranged. He was baffled. He tried to perform on my uncle. কাজটা হলো হচ্ছে রাইট ছেলে মানে ডিজিজ son failed. Senior citizen, he was back and he tried to catch hold of his number.
But yeah,
He tried to,
but yeah, that's my deceased son. Sorry.
Attachment because he was hitting his father. Fail in the level, we have seen this grandmother stuff. My grandson was put darkness. So what was the recovery? How he expired?
Similarly, page 14, Lordship.
Now this statement is partially in his favor.
I have just repeating transfer. This is the audio.
Caesar list.
Page 14, Lordship. Okay, it was at the PO, Lordship. You showed the weapon. It is on page 24 of the petition also, Lordship. Their file.
Yes, procedure from home for the PO box, please.
From the place of at anybody's instance.
Lordship, as from whom is as shown and identified the accused person. It was from the house compounder.
It is in the FIR itself. It is shown that
evidence started.
No, Lordship.
There is no premeditated mind for committing any offense of murder and all. Number one. Admittedly, sorry.
Selling supers. Lordship, the complaint has been examined.
Yes, Lordship, I annexed it.
Yes, that is at page.
Page at-
Certified copy.
Certified copy, which page?
Lordship, I page it.
Last 3 pages.
Last 3 pages.
Oh,
September 2020, 17th.
Lordship, in the charge sheet itself, sorry.
no, last is the bail order.
No, prior to the bail order.
Sessions case 1 of
The
2024.
grandmother of Unu.
Declared hostile. Then?
Yes.
Was examined by.
Lordship, may I share one thing? Lordship, there is admitted.
Please. It is said by the learned advocate on behalf of the petitioner that this accused
For 39, I beg to appear on behalf of the petitioner, my lord. Well, I am appearing online, my lord.
Yes.
Well, may I audible? Yes. Well, it's allegation under 420 and 406 of the Indian Penal Code. The petitioner 1 is the mother's son and petitioner 2 is the father. Petitioner 1 is the Monojit, she is the son. And 2 is the Malad, is the Ujjwal Das, he is the father of the Malad petition number 1. Now, 1 Ombika Roy Malad made them complain. Like he is Malad's complaint. I annexed the petition is page 10. Like also kindly Malad peruse the page 10 of the petition. Malad is a Bengali written complaint, my lord. Malad he said that Malad he give money 2 lakhs rupees to the accused number 1. That is the Monojit. Malad date is not mentioned. And when it is given, it is not mentioned. It said it is given 2 lakhs rupees in cash. Well, is kindly lordship said is the middle portion of the complaint, my lord. Well, 1 নম্বর অভিযুক্ত কারী আমার ঘনিষ্ঠ হওয়া সুব্রতে এবং আমার খুব যেহেতু আমার পুত্র পড়াশোনা শেষ করে বেকার আমি তাই প্রস্তাবে রাজি হই
সে আমাকে বলে প্রস্তাব দেয় যে 2 লক্ষ টাকা তখন পরিশোধ করিলেই আপনার পুত্রের কোভিড যোদ্ধা মানে কোভিড যোদ্ধা ইস মিনস মানে ইস 1920 মানে we can presume that মানে this alleged incident they are talking about মানে 5-6 years back. And my lord is said কোভিড যোদ্ধা হিসেবে সরকারি চাকরি হয়ে যাবে বলে সর্বোচ্চ 2 মাসের মধ্যে পরবর্তী সূত্রে ঘনিষ্ঠ হওয়ার থাকায়
কোভিড যোদ্ধা কর্মী হিসেবে সরকারি চাকরি হয়ে যাবে।
হ্যাঁ কোভিড যোদ্ধা ইস মানে ইস 2020 মানে ইস মেবি 2020
তারপরে মনোজিৎ দাস আর উজ্জ্বল দাস। There are two accused persons.
And he said but he paid in cash. What is a fabulous allegation? And my lord, is a 41 notice police has not given. There is a specific direction of the Supreme Court. There is a judgment of my lord, is a 2014-8. Like it should be given within 14 days of the lodging of the FIR. No 41 notice, nothing. My lord, I am the petition number 1 is the worker of a cold storage.
They are taking money to give them assurance that they will give the government job.
Why didn't you call him 41?
Sometimes there is a racket, so his arrest is very much required. From the
What?
Not only in this case, earlier action they have to 90,000 from another person.
Is there any case? No case.
Has been lost. Investigation is going on.
It is going on.
Case not filed. And the case has been instructed on proceedings.
Whose statement of understanding?
Radhamoni.
Urgent.
Who is Radhamoni?
Radha is another victim, lordships.
Acha, then. Ombika Rai. Who is Ombika? Who is the complainant?
Ombika is the complaint, my lord.
বলছি যে মনোজিৎ দাস উজ্জ্বল দাস প্রস্তাব দেয় তার বিনিময়ে আমি
চিন্তা ভাবনা করে
মনোজিৎকে টাকা দিই
চাকরি করে দেয় না, টাকাটা ফেরত চাকরি করে দেয় না কি অনেকের থেকে
পরে শুনেছি অনুজিৎ অনেকের থেকে কিন্তু মনোজিৎ করছে উজ্জ্বলটার তো কোনো ব্যাপার নেই। Ujjwal is the father.
Ujjwal is the father.
Ujjwal has no connection. And your 164 has made omnibus statement collected from many others. Ashu, Mr. Ganguly,
well,
1 you surrender, 2 we are giving.
Yes, my lord. All right, my lord. 1 is worker of a cold storage. How can he give job? My lord is a frivolous
How
allegation.
will you know that? Can you know that?
My lord, he is the worker of a cold storage. He is also searching for job. My lord, he is a 28 years boy, my lord, 2 lakhs rupees, no date. How has been paid? My lord, is easy to say. I give money. Why you give money? And whom you give money?
Ganguly learned advocate appearing for the petitioners submits that the petitioners have been falsely implicated. The allegations labeled are unfounded. No specific overt act has been attributed to the petitioners, and in view thereof, custodial interrogation may not be necessary. So, Sarkar learned advocate now drawing our attention to the 1/6 statements of the witnesses as recorded under section 164 of the code. Mr. Sarkar learned appearing for the submits that there are specific allegations and investigation is still continuing, and in the said conspectus, custodial interrogation may be necessary. Prima facie, no specific overt act has been attributed to the petitioner number 2, who happens to be the father of the petitioner number 1. Stop. Considering the nature of accusations and the extent of complicity of the petitioner number 2 in the alleged offense, we are of the opinion that his custodial interrogation is not necessary. Accordingly, 10,000 2 sureties 1 local with a further direction that the petitioner number 2 shall meet with the investigating officer once a week and 438 to করে দেবে, হ্যাঁ। However, as prima facie we do find incriminating materials against the petitioner number 1, we are not inclined to exercise any discretion in his favor at this stage, more so when investigation is still continuing.
My lord, only one submission, my lord, is kindly
Partly allowed.
My lord,
Disposed of.
only peruse only one judgment, my friend is there, my lord, is 2014, my lord, volume 8, 273. Let's say 2 copies given, my lord. Kindly consider, my lord, page number 281. My lord, last page of the judgment, paragraph number 11. Let's say Supreme Court judgment specific direction has been given 11.6. Please, notice of appearance in terms of 41A of CRPC be served on the accused person within 2 weeks from the date of institution of the case, which
Yes.
makes, this notice is not served. Nothing has been done. Kindly consider 11.7.
400 is the allegations are there.
It's below 7 years. He's have to serve. But police have no choice. He's have to serve. Police have to serve 41A notice. If I will serve, I will comply. If the kindly consider 11.7. If not served, departmental proceeding will in the Supreme Court direction, my lord.
Yes. Next.
I'm for the state, my lord. I'm praying for 1 day accommodation, my lord. Because FIR 161, 164, everything is in Nepali, my lord.
Next.
Grateful, my lord.
I'm for the state.
আমার আড্ডাটা লিস্টের কপিটা ছিল আমার এটা কি বল ইয়েস
Lordship,
ডাকস দেখে নাও ঠিক আছে ওকে দিয়ে হ্যাঁ
Lordship, the case has been registered and under section 85, 103, subsection 1 and 49 of BNS. That means 498A, corresponding section of IPC 498A, 302 and abatement. Now, Lordship, Lordship may kindly take the pain to have a glimpse on the FIR, which is annexed in my internal page number 10. Page number 10. Here the petition. Here the petitioners before your Lordship are the father-in-law, second wife of brother-in-law, second petitioner, and third petitioner is brother-in-law. The 4 accused petitioners are total in this case, and the principal accused
father-in-law, next is mother-in-law.
No, wife of brother-in-law. And third petitioner is brother-in-law. Third one is brother-in-law. Now the allegations tendered in the FIR clearly states that the allegation of dowry of rupees 2 lakhs and some ornaments were given to the principal accused, more or less 7 years, because the marriage was the solemnized in the year 2019, and this case has been registered in 2025, almost 6 years 8 months before, and almost 7 years.
When
and
did the death occur?
Death occurred on 14th January
Of
2025.
14 January.
January 2025. The principal accused husband is in custody.
Do you have any children?
Yes, the children of the victim lady, the daughter of the victim lady is at present under the care and nurturing of petitioner number 1, 2, and 3. I have annexed in page 13 the photocopy of the birth certificate of the 3 years old daughter, Monisha Dash, who are in the care and nurturing. The
So, all 161 stated omnibus in nature, but judicial statement of the deceased mother stated that victim commits suicide.
Statement 164 of the deceased mother.
Deceased mother. This
It's
is
a case of suicide.
এটা একটু দিন।
দিলীপ মন্দিরা, হ্যাঁ মন্দিরা দাস, দীপঙ্কর দাস, এই দুটো আছে। দুটো আছে না? You went to the sessions court?
No, it is a concurrent jurisdiction.
If you reject, can you go back to sessions court?
Lordship, Lordship, it's a
No, if you, I'm asking a
no,
question.
no.
Why?
Because once rejected by High Court, the session court will.
Who told you? Who told you that once rejected by High Court cannot go back to
Session court will maintain the judicial discipline.
No. There is a verdict of the High Court. Do you know that?
But Lordship,
5 judges bench verdict.
The session court can
Maintainability of second anticipatory bail application. There is a 5 judges court verdict. Do you know that which matter? Sudeep Sen.
Sudeep Sen. Lordship,
Read the last paragraph.
Lordship, in a similar matter, the Lordships were pleased to enlarge the in-laws on bail. That was also case of 103. Lordship, on the day before yesterday. Clear case of suicide. Clear case. Two thousand nineteen. 2019.
6 years of marriage. 6 years of marriage. 2019.
There is specific allegation against you.
Lordship.
164.
Lordship.
And
What
it
is
is a
stated
case
in-
of hanging, not a suicide.
Lordship, hanging is if antemortem in
Hanging is
nature,
antemortem.
antemortem in nature, that is obviously suicide because in 2 occasions it will be considered as suicide. So far, my little understanding subject to correction of your Lordship, that non-continuous ligature mark and obliquely encircling. If it is obliquely encircling, that is means indirectly encircling. That is suicide.
Hyoid bone was fractured.
All bones will be fractured in the neck, obviously. Obliquely encircling, if then it is a suicide.
Touch it, submit, not submit.
Pending, Lordship.
Pending.
Lordship, in-laws, Lordship. And in the FIR clearly stated, father-in-law is a senior citizen. And Lordship, I have given the in same occasion, same similar case, same section, in-laws have been granted by your Lordships.
We did a wrong. Now we have
Major lady lordship, aged about 40 years lordship.
And who are you?
Lordship, I am the near relative lordship.
No, you are wrong. Age is about 21 years, not 45 years.
Having three child lordship.
So what?
Lordship, then I correct myself lordship.
So since she is having 3 child, you thought it is 40.
Lordship,
That is the presumption you are drawing.
lordship, the accused person is the near relative lordship. That is
Yes.
the accused person is the victim's sister-in-law's husband lordship. Lordship,
আচ্ছা চার্জশিট সাবমিটেড
No,
দেখি 164 টা
164 and
lordship,
my lord,
kindly peruse the
এটা মেডিকেল
one medical thereafter 160.
প্রাইভেট 164 is at
164 is at page 46, 47. In absence of his family member, he entered into the room in a midnight and forcefully ravished her.
lordship kindly
স্টেজ কারেক্টলি ঘুরিয়ে বলে রেকর্ডেড স্টেটমেন্ট এর নাম what is the name of the victim?
Victim name Alpona Khatun.
Jyotsna boy. No, Jyotsna. Which is the victim 164?
This one, below. The name. There is 2 copies.
Huh?
Same 2 copies.
Oh, acha.
Both are same.
lordship, now kindly peruse the para number 6 of my petition lordship. This is the actual truth lordship. Dear relative lordship, out of the family dispute to
Where
distribute
is the medical?
My lord, medical at page
lordship distribution
1990.
Yes, yes, Your Lordship. Actually, Your Lordship, on the last occasion, there was Justice Ravi Kishan Kapoor's bench. It was listed on 3/1/2025. So that time we were on courtroom number 2. We that time it had been considered dismissed for default. In that circumstances, we want that matter to be restored and connected to the original file. No, yeah. It's actually, yes.
376, Lordship. 670. No, Lordship, today case diary is not produced. After restoration, case diary produced. Lordship.
Kindly,
That is the explanation.
we were not present at the time. No, I have the brief, but that main, no, my senior is in matter. Anirban Banerjee. Today he couldn't able to come to court.
Why you have where you stated that you did not appear?
That, yes, CRAN 1 of 2025, that application. Your Lordship, number 3, para 3, it mentioned. Grateful, Your Lordship.
49 for the. I'm for the state. Yes, my lord.
Yes,
Same,
yes,
same.
yes. No, I have. That is.
My lord, one CRAN is filed for condonation of delay.
Yes, condonation of delay is there.
And one CRAN for restoration.
A 10 days delay, Your Lordship. Actually, we are shifting our chamber, so we missed our brief that time. So we got the brief after that, and subsequently we.
My lord, next circuit. Petitioners, my lord. There are two petitioners, my lord. Grateful, my lord. Grateful.
Grateful.
How about the petition number 2? Restoration petition, madam. On one date I missed. Paragraph number 3, madam. Three, my lord. Yes. No, that is how I have filed today, my lord. I am craving leave. I am craving leave, madam. It has already been filed. I have got the copy also. Only 4 days delay, my lord. হ্যাঁ হ্যাঁ এই যে আমার কাছে কপি আছে আজকে ফাইল হয়েছে ইট ইজ অলরেডি মেনি
ও আমি আছি তুমি জানো
নাম দিয়ে
Restoration application.
But condonation delay 7
Yes, 7 days delay, I have narrated the delay. I have explained the delay application in paragraph number 9. Lordship 52, Lordship in this 52 matter, Lordship, that the order sheet, bail order has been granted, written in Jalpaiguri in place of New Jalpaiguri. It will only add New Jalpaiguri. That's why they didn't take the. Yes, my lord. No, madam, 51 হয়েছে. Lordship, the order has been passed. In the cause title, Jalpaiguri PS case. New Jalpaiguri. In place of New Jalpaiguri, written Jalpaiguri. Vishwarup. Vishwarup. Lordship, only the modification New Jalpaiguri. In the order, Jalpaiguri is written. Correction. Only one add correct. New Jalpaiguri due to. Lordship, the bail petition not accepted by the court due to the. Vishwarup Roy. Yes. Junior কে আছে Vishwarup Roy?
Yes. 53, I'm for the state, my lord. They prayed for
For the petition.
relaxation, my lord.
Lordship, item number 53 is for modification. I'm praying for modification on 2 grounds. Point 1 is his wife gave birth of their child on 15th of December 2024. It was very difficult to come and praying for his regular bail. 15th of December 2024. I have annexed the birth certificate also.
Yes.
Yes, Lord.
The order was passed on 2nd January. You did not say that. The order was on 2nd January.
Yes, Lord.
Say that the Union Party.
Yes, Lord. He's also a fisherman by profession. Yes, Lord. 15th of December.
Then what is the explanation here given?
Lordship, kindly modify.
Lordship, kindly modify the local surety into registered surety because he is a fisherman by profession and he works at a fish shop.
Fisherman or electrician?
Fisherman.
You electrician, anyway.
So it is very much difficult for him to surrender and furnish the local one.
One is local, my lord.
So
The
she
problem-
finally realized the local surety into registered surety. Because he is not the local resident of. Hmm.
Item 58, Millard, tomorrow anytime, Millard, subject to lordship convenience, Millard, for. So today there is a resolution, Millard, I want.
Lordship, item number 58, for what is accommodation? Lordship, for what accommodation?
Yes, my lord, that matter, POXO matter, my lord, where the parties wanted to marry each other, my lord. That POXO matter, your lordship. Lord, my lord, it is definitely not a ground for bill, but this is a concocted case, my lord, that is a ground, that is my ground, my lord, my humble submission, my lord. My lord, I am just 20 years of age. My lord, I cannot marry her legally right now. My lord, the day I turn 21, my lord, I am ready.